declare that let this matter be declared after 4
Much.
When was 64 and 55, they will actually after 2 they consider the other side.
Heard Mr.
Take care of it.
A.K. Ahmed, counsel for the respondent, who prays for an adjournment with the consent of the counsel for petition. Declare
15
no fix, considering the submission made by the declare for adjournment is adopted this matter be declared after 2 weeks.
68 to 74. Any other prayer?
If I am praying for listing on matter, your lordship, for usually
When
on tomorrow, your lordship.
please, your lordship. I beg to mention for listing for motion matter, your lordship. Tomorrow, your lordship.
when have you
For file, your lordship, 24/11/2023, your lordship. Serial has already been done.
I recommended for listing on intensive bail application, lordship. I filed yesterday, lordship, on 1st December.
I recommend for listing motion matter, my lord. We just file 15 not listed.
on 15th you have filed?
My.
Okay. When you want?
Next Monday, my lord. And another prayer, my lord, I criminal appeal. I remain in last 9 months in jail custody. So, next
Criminal
my lord,
appeal for what purpose?
my lord, conviction.
No, for why?
Orders, order,
For orders you
order.
have-
Order.
May I please, your lordship. Therefore, listing a matter, lordship, tomorrow itself. Matter was fixed today, lordship, but unfortunately, matter is not listed. Juvenile case, before releasing a juvenile. Tomorrow.
Very much.
Ma'am, what you are taking for AP?
May I please your lordship? Lordship, I beg to mention item number 38 of today's list. Lordship, case diary was called for. I am on interim bail. CD is not available.
Or Mr. Q. Mr. Counsel for Miss Bora, who prays for an adjournment, who prays for some more time for producing the case. Where is the law?
19th.
Let this be declared on 19th of the interim of the chair.
Oblige, your
May I please, your lordship? It's a bail matter. Lordship, it was listed on 10/11/23. It was supposed to be listed after 2 weeks, but till today it has not been listed. Kindly fix the matter on list the matter on 1/12/23.
Listing of a hearing matter, lordship, criminal appeal, very urgent matter, 2017 matter. Appeal second secretary, lordship. 2 respondents already died, lord. He also,
No, hearing, it will have
yeah,
to
urgent
come.
matter, lord.
What urgent?
Actually, 2 respondents already died, lord. Another also about to die, lord.
No, you file a prayer for expeditious hearing.
I have approved for the registry.
No, you have to file an interlocutory application praying for
Already
expeditious.
filed, lord. Already filed, it was listed, already listed. File listed on 15/11.
You have filed an,
Yes, already allow the petition. lord.
okay, when do you want? Your,
Also, any-
your
any-
interlocutory application has been allowed.
Already allowed. Already listed also the hearing column, but does not reach that matter. Earlier, reached to us on a 15/11.
Next week,
That date. Next week, any date.
Fourteenth.
14th.
Omelette.
Daily list for motion item 1.
May I please, your lordship?
Lordship, in this matter, lordship, the report was sought for, lordship. So that report perhaps Ms. Jahan was supposed to take. She's not here today, lordship. Can it be tomorrow, lordship? Just now I have come to know.
Okay, let it be. On the request of the additional public prosecutor, let this matter be declared again.
Lordship, obliged.
The additional public prosecutor shall ensure that the report which was called for by order dated 21/11/2023 produced before this court tomorrow.
All
Item 2,
May I please, Your Lordship, in this case, my lord, the petitioner has approached before this honorable court arising out by judgment and order, my lord, passed by the principal judge family court, Nalbari, my lord. Your Lordship will kindly stay at page 10, my lord, this judgment, my lord. My lord, at page 13, my lord, after my lord, completion of the submission of
Permanent
the,
alimony,
my lord.
permanent alimony.
Yes, my lord, permanent alimony, my lord. Yes, admittedly, the petitioner does not have any income, my lord. That is why the petitioner has approached before the normal court for modification and alteration of the order, my lord. So, maybe if notice may be issued, my lord, to the respondent, my lord. In the meantime, the MP order may be kept in abeyance. This is my humble prayer before the normal court.
Our Mr. W. Rahman, that the counsel for his application under section 397/401 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Jitu Kalita, impugning the judgment and order dated 7/9/2023, passed by the principal judge, Family Court, Nalbari, matrimonial suit number 141/2023, whereby the petitioner has been directed to pay an amount of 1 lakh to the respondent as permanent. Issue notice. Issue notice. The petitioner shall take steps for request by registered post within 3 days from the date of his order, returnable after court. The prayer for interim relief shall be considered only after service of notice of respondent.
Till the returnable date, my lord.
No, let the notice be served on next date. Let this matter be considered again. Whether any fixed date has no fixed date is given for payment of it by the bank.
My lord, within four months, my lord, it has been given by within 4 months. Your lord will kindly stay at page as 26, my lord.
So time is there,
Order is there, my
sufficient time.
within four months, my lord. Already 2 months is over, my lord.
Okay, we will consider your prayer for interim relief after service of notice. Let this matter be considered.
Okay.
item 3,
May I please, Your Lordship. 238 application, my lord, allegation under section 364, my lord. And it is the allegation as released in the FIR case 13, my lord. My lord, first part, my lord, there is some monetary transaction between the victim and the informant, petitioner, my lord. My lord, admitted fact that here mentioned 1 lakh rupees has paid by the petitioner to the husband of the informant, my lord. It was admitted. Second part, my lord, today, 31st 10 2023 at about 7-8 o'clock, my husband went to Nayahat with Tahangir Hussain by bike, and on the way back he was dropped at Balukmari Ghat and fled. After 15 minutes, Zohrul Haq Ali Islam, resident of so and so, and two other unknown youth kidnapped my husband, namely Amir Hussain, through their bike. Now I don't know where my husband has been concealed. This is the allegation, my lord. My lord, actual fact is, my lord, the husband of the informant, my lord, has taken rupees 3 lakh with the condition to provide 20 number of labor to the brig industry, my lord, by executing an agreement, my lord. My lord, kindly visit the agreement at page 16, my lord. But he misappropriated the whole amount, my lord. The proprietor, original proprietor of the big industry, my lord, pressurized the petitioner to trace out this victim, my lord. Accordingly, on the 31st day, my lord, the petitioner was caught and produced before the proprietor of the big industry, my lord. And the content of the
So
FIR
you
is
are
clear, my
admitting
lord.
that
In
you
presence of
kidnapped.
informant, my lord, the victim was taken, my lord. 7-8 o'clock in the morning, my lord. How it is kidnapped case, my lord.
No,
Thereafter, my lord, he is still working with me at Tripura, my lord. My lord, I annex another declaration made by the victim himself, my lord. Page 19. Page 19, my lord. Victim is recovered on the same day, my lord. He has taken rupees 3 lakh and fled.
What is page 19?
Page 19 minute declaration made by the victim himself, my lord, before the proprietor of the brick industry, my lord. He has taken rupees 3 lakh. He returned back the same and he promised to work in the state factory with 20 number of labor, my lord. This is the declaration,
No, the issue here is whether you abducted the
my lord. Already, my lord, 2 accused are arrested, my lord. The Ali Hussain is no involved in this case, my lord. Present petitioner is Ali Islam, my lord.
what has happened to the arrested?
My lord, he is in custody, my lord.
They are in
Custody, my lord.
City of the required.
Custody.
a connected matter is also pending before
My lord, my lord. My lord.
when the case there is fixed,
Case very fixed on my lord 12.
let us fix it.
Lord,
But till then, my lord.
No, after perusal. Our Mr.
Alright.
R. Ali, the council for the also heard this message for considering the nature of litigation level FIR perusal of the case that hence call for fixing 12 for
Obla. Please. It is 38 April, my lord. That is page 8. FIR page 8.
page.
My lord, in this case, my lord, I am not a name requestment. My younger brother said to be kidnapped the victim guard, but the police pressurized me to produce the girl uh, from my younger brother. I do not know where my younger brother is living, where the victim girl is missing. I do not know. Although I have been pressurized by the police and take a promissory note, my lord, annexure B, kindly see, page 10, my lord. Page 10, kindly see, my lord. With due respect, I would like to inform you that before 5 months from today, my younger brother Muhammad Imdadul Amin kidnapped the victim of village Salamara Khat in connection with PMR PS case number 7120.
Now whether police is trying to arrest you,
Threatening to arrest me, my lord. Therefore, I have come to the court, my
let him
let him be on internet.
heard Mr. A. N. Ahmed, Senate Council for also at this message for others. Its application on the section 438 of Code of Procedure for 1973 has been filed by the petitioner Rahul Amin, who is apprehending his arrest in connection with Elamara PS case number 71/23 under section 366 of the Indian Penal Code. The gist of accusation in this case is that on 8/6/2023, one Sufia Begum had lodged an FIR before the officer in charge of Elamara police station inter alia, alleging that the daughter of the first informant went missing from her house on that day at about 11 a.m. And she came to know that her daughter is with one Imdadul Amin, with whom she had love affair. So, learned counsel for the petitioner submits that the named accused in the affair, that is Imdadul Amin, is the younger brother of the present petitioner, and only because of the fact that the named accused is the younger brother, the police of Thelamara police station have has compelled the present petitioner to execute a note on 7/11/2023, execute and give an undertaking before the police on 7/11/23 that he would recover the victim girl within 15 days from the date of the said undertaking. Learned counsel for the petitioner has submitted that the accused in the instant case is the younger brother of the present petitioner, and he does not know about the whereabouts of the victim. However, the police is searching the present petitioner and he is apprehending his arrest. The counsel for the petitioner has submitted that petitioner is ready to cooperate. We are disclosing it,
Yes, doctor.
considering the fact that the bare perusal of the affair would show that the brother of the present petitioner, named Imdadul Hussain, has been specifically named in the affair, and no allegations are made against the present petitioner from the petitioner, namely Rahul Amil, is hereby directed to appear before the investigating officer of Kalamara PS case number 71/23 within a period of 10 days from the date of his order. If he does so within the period of 10 days and cooperate immediately. If he does so within the stipulated period of time, he shall be allowed in the event of his arrest in connection with Kalamara PS case number 71/23. He shall be allowed to go on bail of 30,000 with one purity of life, subject to satisfaction of the arresting authority with following. With above observation, this anticipatory bail application is thereby disposed of.
Item 5,
Maybe Lordship, but for 30 application Lordship. The husband and father-in-law is accused in this case Lordship. The husband only granted bail by the IO Lordship. A family dispute Lordship. The father-in-law petitioner is the whole person who tried dispute this Lordship. Case is FIS base 9 Lordship.
Petitioner is the father-in-law.
Father-in-law Lordship. Allegation against him is 376 Lordship. The family dispute Lordship.
Against
Father-in-law.
Against father-in-law, there is a
allegation is
allegation
under
of forceful rape.
Yes,
against-
376.
Yes.
Case diary would be required.
No, Lordship. Can you see? The occurrence happened in the month of January, Lordship. Take note this case is November, Lordship. Can you see, Lordship? Case 9. Last portion, Lordship. In the month of January 2023, when I was with my girl, sat in my room, my father-in-law named Hirakanta Sangmai kicked my mouth and forcefully raped my advantage husband and member of our family, Lordship. And also, why he has lodged his FIR against me, Lordship? And you see, Lordship, it's counter blast FIR, Lordship. Case 19. Page 19, Lord. This family member, Lordship, publish a public notice, Lordship, by making. After that, I have closed the case, Lordship. Now, after that, I inform my lodge this case after 8 months.
No, where is the,
Yes, sir. Page 19, public notice, Lordship, for family members of the informant, publish it. And I lost the case against them, Lordship. And after that, the informant lost this present case, Lordship, after 8 months of incident. After 8 months of incident, Lordship. Countered last affair. My affair is page 21, Lordship. My case is one PS case number 107 and this present case 108. It's the page 21. 21 of my.
what is the 21?
21. I have lost this case
What,
against the family members of the informant, Lordship.
what have you alleged?
Yes, Lordship. Page 19, Lordship. The family members publish a notice publicly, Lordship, by making some false defamatory statement, Lordship. Page 19.
I need the case here, Lordship.
That is the interim protection order given, Lordship. Only to harass me, Lordship, nothing. Incident happened in the month of January, Lordship. Just lost this case in month of November, Lordship.
He
And she has
was,
stated,
he was under threat not to disclose the fact in
No,
front of
she-
the others, Lordship.
she was not here,
As
Lordship.
per the affair is concerned,
she was in
it's
Hyderabad, Lordship.
anticipatory bail, Lordship. He's not behind the bar.
He was in Hyderabad,
So
Lordship.
let us
Kindly see
call
page
for the
11, Lordship.
CD at least.
Let us give a short date.
Yes,
No, Lordship,
Lordship.
kindly see. She was in Hyderabad,
No,
Lordship.
we
She
are,
status here.
we
Lordship.
are, you are coming to this court after 1 month.
Plus, I have lost this case before session last, Lordship. Kindly see.
Session
28.
judge has
Yeah.
rejected your order
Yes,
Yes.
yes,
after
Lordship.
perusal of it.
Yes,
Yes.
Thus, Lordship, they have stated, Lordship. Thus,
Let us
Yes,
peruse
yes.
the case.
this is Lordship only interim. She's retired person, Lordship. She's all years,
No.
Lordship. That discharge headmaster, Lordship.
After perusal. Heard, Mr.
These like
B. Sai,
D.
B. Soikat, the counsel for petition. Also heard Ms. S.H. Gaurav, the petition. Considering the nature of allegation, they will against present petition.
After 8 months, Lordship, yes, so
Perusal of the case diary would be necessary. Hence call for the case fixing
Lordship 11, 12.
11
Okay.
or case.
like.
Charge sheet case, at this stage, lot may call for the scan copy of the FCR.
Heard Mr. N. J. Dotto, the counsel for the petition. Also heard S.H. Gaurav, the petitioner. Considering the fact that in this case, charge sheet has already paid perusal of scan copy of PRP case number 761/2023, as well as case diary of case diary would be alternate
Yes,
Yes.
Sorbo PS
case diary of Sorbo PS case number
170 of 2020.
170 of 2022 would be required for consideration of the package application. Hence call for the
Lordship.
registry to take steps for the petition
Lordship.
scan copy.
Any date, Lordship.
Let the case be fixed again. 21.
That judicial magistrate has
JMFC. Borpeta.
or for court of judicial magistrate for-
I'm applying.
May I please? Under the 439 age application, my lord, there are about 10 accused persons. My lord, all have been charge sheeted, my lord, but 3 names were left out, but we have, our name has been shown as absconded. We live in the same vicinity, my lord, but police never came to us. Now we since we have come to know from other co-accused that we are also being wanted by the court. So we want to appear, my lord. We want your direction, my lord.
in this connection, I have annexed two judgments. One is our own High Court.
Whether the court has issued summons to
My lord, it is issued someone, but I have not annexed it, but I'm avoiding their police arrest service, my lord. That's why I want to appear, my lord. Kabir Ahmed, I have annexed, my lord, how to, the 82, 83 of CRPC has not followed. Then, my lord, latest judgment of Apex Court, my lord, Aman, my lord, where I take your lordship only three points, my lord, page 41 kindly.
what is the maximum punishment under section 307?
Life also can be.
If
That is there.
parties cause them,
In this
But
case,
my lord, in a similar case, our own High Court, as well as Supreme Court, your lordship has granted clearest bail and direction to appear. I have annexed two judgments, one Supreme Court and one High Court, and another two judgments are with me, my lord. I can place before your lordship. One is by your lordship. Two judgment I have annexed, my lord, as an annexer.
Ms. Gora,
Lordship.
whether no, why are you apprehending that you will be?
Because my name is there, my lord, in the charge sheet, my lord.
In the search sheet showing him as absconder, thereafter duly the court someone has been issued to him.
Summons are issued,
Yes, it is issued to me,
That
but
is
I have not
issued.
yet been received.
but
Then where is the illegality?
then if summons are issued, why are you apprehending?
My lord, you know, my lord, what will be fate? Your lordship also Supreme Court also discussed this provision. When the summons should be issued, if I accept it, I have to appear, then I will be stand behind the bar. My lord, page 41, the relevant portion of the Apex Court observation of this type of cases, my lord. I am reading just one line, my lord, kindly. Rejection of an application for exemption from personal appearance or date of the hearing or as a first instance does not amount to a non-appearance despite the service of the summons or absconding or failure to obey the summons, and the court in such case shall not issue the warrant of arrest. That the court shall appear in appearance of the accused in a bailable offence shall release him forthwith on his furnishing a personal bond. Then the court shall, on appearance of the accused in a non-bailable offence who was neither been arrested by the police investigating agency during the investigation, nor produced in custody on as envisaged in section 170 CRPC, call upon the accused to move a bail application. If the accused does not move it on his own or release him on bail, as the circumstances of his having not been arrested during the investigation or not being produced in custody is itself sufficient to entitle him to release on bail. Reason is very simple. If a person has been at large and free for several years or has not been even arrested during the investigation, send him to jail by refusing bail suddenly merely because of charge sheet has been filed in against him, principles
No,
governing grant of refusal of bail.
That is not the issue here. Issue is case has been charge sheeted.
Yes.
Summons are issued against.
Yes.
Then where is the fear?
Well, if your lordship, the dispositive direction that I will appear on direction to consider my bail, then I have got no objection. I am afraid that I will be sent behind the bar.
That will be decided on merit, lordship.
They cannot be married because the Supreme Court has given a guideline. And because wherever the absconder has been shown without following the 82, 83 of the CRPC, our own High Court judgment, Kabir Ahmed, as well as the Nurul Islam,
No,
these
you
are
are
following.
not to the point.
Beg your pardon.
You are not to the point.
Yes, yes,
You are apprehending that you may not be granted bail.
yes.
Yes, that is the only.
Why that apprehension?
Well, you know, the usual courts we have seen, Melody, in my 50 years of my practice, I have seen that they are being sent to
That
jail,
is,
Melody,
that is not a
because their offense is non-bailable. That's it. If your lordship give some observation that his bail may be considered, then I have got no objection. I will appear.
no. What is the punishment for 307?
If parties. cause
My
the
lord, it may be less than life or
imprisoned
if
for
it's
life,
serious,
lordship.
but nothing is there. There is no such medical evidence. Well, if your lordship wants to call for the scan copy of the matter, whole
Then
thing,
lordship may
your lordship
recommend
will
call
appear
for
before
the
your
scan
lordship.
copy at this stage.
Okay, let us.
But your lordship has own judgment is there, my lord. Our own High Court judgment, my lords have given similar judgment.
You are-
Following your judgment, my lord.
You are not answering my question.
Yes, yes, my apprehension. Apprehension I have very honestly submitted, my lord. I am afraid I will go inside.
Why?
Because the section is unavailable. Moreover, there is
Where-
absconding. I am absconding.
Where non-bailable section is not enough, because in non-bailable section, committal court may grant you bail. Is there any bar for the
No
committee?
bar, but the court, it is the complete
you
discretion
have
of
to
the
choose
honorable
the-
court, my lord. Complete discretionary. In all bail matter, the principle of bail, not jail, is never followed, my lord. That is the problem for
No,
us.
you are not to the point.
One second, I will explain, my lord. Kindly tell me.
My,
Apprehension, you are always.
we are calling for the scan
Scan
copy.
copy of
When,
it.
when is the next date?
My lord, it is 16. 16 of December.
Before that, we are fixing.
I am ready to appear tomorrow if you lord give me the direction, my lord. But I want to face the trial because I have not committed any offense. Police never apprehended me earlier.
Mr. S.C. Vishwas, learned counsel for the petition. Petitioner also heard with S.H. for the petition. Considering the fact that charge sheet has been laid in this case and as submitted by the counsel for the petitioner, the petitioners are shown as absconded in the charge. Perusal of scan copy of the case record of PRC case number
Lord, case number is RK Nagar space code 51 or 14.
that is PSK.
Yes, charge sheet number. I am
case
giving.
number.
Charge sheet number, my lord, 11 of 2016 before the session judge.
Not a PRC case.
Now, which court has issued summons to?
Session court, my lord.
In which case?
This case, charge sheet case.
No, give me the number of it.
Charge sheet I have
case
given.
number.
my lord. Charge sheet number is, my lord,
Not a PRC case number.
PRC. PRC case.
Before which court you will appear? You punish the.
I'm
detained.
giving.
Lordship, note down the GR case number. That is
Charge sheet case of 11 of 216, my lord.
Case and copy of the case record. Here, case number
1281
1281 slash
2014.
2014 from the Court of Planet.
Additional CJ time bomb.
Let this case be listed, be registered to take steps for requisitioning the scan copy of the case record. Let this case be listed again. 13.
Item 8,
Lordship, LCR along with the TB may be called.
Along with the case.
Case time.
If you can show me,
Scan copy.
Mr. Vishwas,
Yes.
on the next day, that there is some legal bar on the part, on the committal court for granting bail, then you may have a. Not,
My
what-
lord, in a.
no, I want
accused-
answer
My lord, in
on
a
the
case-
next day. 13.
item 8,
None appears. Call it after some time.
item 9,
May 3, 438 CRPC bill application Lordship, FR page 13.
Case diary would be
What date may be given?
Mr.
M.A. Mundal.
M.A. Mundal, counsel for the petition of the petition. Considering nature of allegations leveled against the present petitioner, the affair, perusal of case diary would be necessary for consideration. Hence call for the case diary. Fixing
1312.
13.
Obliged.
item 68 of the supplementary list,
Today there are many cases. Yes.
Yeah.
Item number.
Item number 68, Lord, supplement petition.
Lordship, is a check bouncing case. Now, how it arose? The opposite party number one, he pretending to be the owner of a flat, offered me to sell his flat. And accordingly, he started to receive payment from 2017. And thereafter, on 11/4/2018, he got executed a MOU with me. And on 12/6/2018, he has already received payment of 47 lakh out of 51 lakh. And those are Annexure 3A and B. And thereafter, he got the check bounce, both the check bounce. Now, what happened, Lordship? Only 4 lakh to be paid to the opposite party number one. But till receiving the two check, he was not the owner. And thereafter, on the basis of the return memo for 4 lakh, he retained rupees check of 10 lakh is 20 lakh. And those checks got bounced. Thereafter, he filed the CR case number 6512. And accordingly, notice was issued. Then I appeared, offense was explained to me. Now, these are the facts. Now, what happened, Lordship? After initial deposition, he has annexed as many as 12 documents. And thereafter, before cross-examination, he filed a petition under Section 311 of CRPC for introducing some documents like sale deed, which were subsequently obtained. Those were obtained sometime in the year 2019. And he was partly crossed. Now, thereafter, again, he filed another petition under Section 311 for adducing more evidence. And we objected. Thereafter, the learned trial court passed the impugned order. Now, Supreme Court has settled.
Where is the impugned order? At page?
Impugned order. Okay.
At which page?
Last page.
64 onwards, Lordship.
64, 5, and 6. Lordship. Now, there are certain guidelines. Lordship. That must relate to fact-in issue. But this is a check bouncing case. Under section 138, only 4 conditions are required to be fulfilled. But he has introduced now agreement to sell. Earlier he introduced sell with mutation order, etc.
When is the date fixed? Now
Date is fixed on
you are impugning the order by which the court allowed the
petition.
petitioner to adduce additional evidence.
Lordship, without showing any reason. Learned trial could hold that the agreement to sell is irrelevant. That is my question. Whether that can be introduced, whether check bouncing case relates to any right, title, and interest of the opposite party, number one.
When is the day?
Next date is 1st December. Okay? 1st December.
1st December
For cross-examination. We have already examined, partly cross-examined, but due to paucity of court, cross could not be completed.
we are issuing notice, let him appear. Let him appear and
Till then, Lordship, further proceeding be stayed. Till then, at least till his appearance.
no, we are fixing a short date.
No.
No interim.
Lordship, otherwise, case will proceed. Lana trial court will raise up for completion of cross-examination. Thought that may be fixed.
Heard Mr. A. Sahab,
Uh,
A. Sahab, learned counsel for the petitioner. Also heard Ms. S. H. Gora, learned additional for the prosecution. This application under section 397/401. Whether this order revision is maintainable,
Pardon?
the impugn order is an interlocutory order or
Then it is.
Actually, if you know, what is prescribed in this judgment is that only truth. And that must be issued.
no, there may be, the opposite party may raise the question of maintainability.
Yes, Lordship, otherwise it cannot.
That may be, they may
This,
raise it.
this application under section 397/401 of the Code of Criminal Procedure Common 1973 has been filed by the petitioner Srimati Baby Saha, impugning the order dated. Which order you are impugning?
Lordship,
Impugning-
at page 64, dated 15/06/2023,
Impugning the order dated 15
06.
15/6/2023. Passed by learned judicial magistrate first class in first class Guwahati in CR case number 6512C/2018, whereby the opposite party's prayer to adduce additional evidence was allowed by the learned trial. You are impugning the order dated 15/6. Then there may be a question of limitation of
Okay, well, within time, we have filed it.
what is the,
We have filed on
We are issuing
18/9/2023,
9 of
9.
issue notice to the
Respondent.
respondents.
One.
Since learned additional public prosecutor has appeared for respondent number 1, the no formal notice need to be issued to the respondent number 2. Additional public prosecutor appears for respondent number 2, no formal. As regard respondent number 1 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from date of this order, returnable after 4 weeks. Let or give it a
5.
returnable on 5. In the meanwhile, considering the averments made in the revision petition, the learned trial court shall not proceed with examination of whose examination is fixed cross-examination. Whose cross-examination
PW1, complainant, PW1.
shall not proceed with cross-examination on the complainant on next date fixed. That is only for one day I am putting.
Next date, yes.
No.
When is the next date?
Next date.
First December.
That is on
1/12.
first of December 2000.
Yes,
Only for that day I am putting.
Yes,
All
Akshay.
after that there will be no one.
not.
Let this case be listed again after court.
69.
Wait, this is the Lordship. Lordship, on last occasion posed some queries, my lord, and we have sought the instructions, my lord, but not received.
Right.
Regarding, here's a bit.
A gentleman listed, a gentleman listed, who wanted to know the reason. My lord, we had applied for the records, we'll get it by today, my lord. So may I play that this matter may be taken up day after tomorrow, my lord?
Okay. Heard Mr.
M.A. Chaudhary.
M.A. Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the ground that they have not yet received the instructions which were directed to be procured by them to answer certain queries which
Yes.
were posed by this court on 24/11/2023. The prayer is allowed. Let this case be listed again on
First of December.
first of
The-
There are a series of admission letters.
We are there, my lord. Just probably one line order will suffice the matter, my lord.
Admission, only this series, thereafter bail.
Admission item numbers 10 to 22.
Yes, yes.
Yes.
I appear in the item 11 and 14 and other matter also.
My lord, will peruse the last order, my lord. That will 11 and 22, my lord. There is a matter pending, similar matter in the apex court.
I think
On
that
the
is
same point, my
same
lord.
point.
So we are waiting for that outcome to
And
come
next
out.
date is 1/12. Tentative.
Tentatively, it may be listed on first of December. Third learned count, I am not
Dictating the names, my lord, to learn it how to so it will probably.
third learned counsel for the party.
Right.
It is submitted by learned
December.
counsel appearing for the parties that similar matter is pending.
Similar matter on the same point, on the same.
Similar matter on the point which, on the question which
Yes.
is involved in the
19
instant
number.
criminal petitions is pending before Honorable Apex Court in criminal appeal number 1269/2017. And it is submitted at bar that the said matter is pending on
Said matter is
fixed on
tentatively fixed on.
tentatively listed on
1/12.
first of December. Hence, an adjournment is prayed for today.
My lord will fix the matter on 19, my lord.
December, before vacation.
18, 19, where 15.
Or let it be after.
My lord, let us make it endeavor, my lord, because of the fact, my lord, there is stay going on.
Okay.
Trial court nowadays.
Let this case be listed on 18th
My
Yes.
lord.
18th
Yes.
of December. Is there any interim?
Yes, my lord. That.
The interim order shall continue. till 19th.
19, then
The date is 19th.
19. Oh. Intensive.
For bail hearing, item 28.
Twenty-eight. 28.
My lord. The CD was.
Lordship, CD has not received, Lordship.
They have not-
No.
They are already up to date since. I 86 days in case of accused number
1 and 4. He was arrested on 5/9/23.
Lordship.
What is the injury which was sustained?
Later on-
Succumb to death.
Or
Later
death?
on,
Succumb to
three
death.
zero
Later
two
on
has
it
been
was,
added.
1302 was added.
When TD can be?
Lordship, it's from Kamrup Haju PS. Short date may be given. Lordship, we'll produce a case.
In the meantime, the 90 days would be over.
Then
In
you
case
will
of-
automatically get bail.
Yes,
Automatically.
let us give a chance. Lordship.
Huh?
Heard Mr. P. Upadhyay, learned counsel for the petitioner. Also heard Ms. S.H. Gora, learned additional public prosecutor, who prays for another day, who prays for some more time for
Demanding.
producing the case that
1 and 2. Side appointed.
the prayer is allowed. Let this matter be discussed again on
Lordship on sixth, Lordship.
The 6th one, 90 days.
In case of one
Up
and
to
four,
Lordship.
Lordship, 2 and 3 is still there.
4. Can be made.
Mandatory period will be over in case of petition number 1 and 4, Lordship.
then they will get bail.
Yes,
No issue.
no issue.
Let it be fixed on 6th.
Sixth, Lordship.
Can it be made 4?
Let it be on sixth. 5.
4, no? 4. 4, then we will mark it.
4 12. I'll try.
Yes, 4.
Okay, good.
Up.
29,
My lord, I have just finished the item number 25, my lord. I am left in another court, my lord, that's why.
No, 25
25
has
is
not
not
yet been
called.
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 This will be called after bail hearing.
item 29 for bail hearing.
Your lordship, I am behalf on my senior, that I am acting over.
Your Lordship, speak
You have to
loudly.
be louder.
Your lordship, I am behalf on my senior, Mr. Ahmad Khandogar. He is in another court.
Okay, we'll take it up
Possible
after
better.
some time.
Otherwise, also Lordship, Sarsit has been late.
Okay, we'll take it after
Lordship.
some time.
30,
My senior was in another court, lordship. That is the first time.
Okay, after some.
Time being up. 31. that's it. 31.
item 31,
May it's a substitute case, my lord, hence 302, my lord. Petitioner behind the bar 140 days, my lord. But your lordships will find
Scan
the
copy has arrived.
yes, my lord. First call for my lord. No, it's like that.
Yes.
But in this case, petitioner is not named at heart, my lord. He has been arrested on 12/7/2023, my lord. He is behind the bar 140 days as on date, my lord. Time accused, Shahanur Islam already granted bail by the first class judicial magistrate, my lord, Avayabri. And
Oh. How many accused against how many accused?
my lord,
Charge sheet has been laid.
4, my lord. Your lordship will find the charge sheet case number 21, my lord.
And how many are on bail?
My lord, only one on Shahanur Islam, the prime accused is on bail. And Baki two, the other 3, my lord, is not in bail. And other 2, except the petitioner approached this committal court, my lord, that was rejected. That's why the petitioner is represented.
My lord, as part of my lord last order, lordship, order dated 10/11/2023. The case was fixed for purpose, lordship, on 16/11/2023, lordship.
My lord,
And
case
there are
already been committed, my lord, before the additional session does, my
definitely
lord,
that is why, my
Mobile, my
lord,
lord, and case is fixed for 5/12, my lord, for production and ceasing.
Have you prayed before bail?
No, my lord, I have not
Before
read
the
because, my lord,
trial court?
about trial court, my lord, I have before the additional sub-division of judicial
No,
magistrate, I
no.
have prayed.
Not before
No, no,
committal court.
no, committal court, my lord, I have not. Because, my lord, other two cases already, my lord, rejected the bail by committal court. I have the information, just I take
My lord,
the information.
one accused person, Sahadun Ali, he was granted bail, lordship, under what circumstances he was granted bail, that I my lord, do not know, because we have to go to the scan copy, lordship. And other 3 persons, they are in jail, lordship.
My lord, is it
And
the-
there are, my lord, sufficient materials against all the accused person, lordship. And at this stage, I am opposing
is
his.
it the
opposing
bail order
their
of the
bail.
Shahrul Islam, my lord, judicial magistrate first class.
No, judicial magistrate first class cannot grant him bail.
My lord, due to, my lord, could not file the charge sheet in due time.
Default bail.
Default bail.
Default bail. Default bail. My lord, bail is not
But
equated.
default bail, then others could also get default bail. If they were arrested later on.
Yes.
There are, my lord, incubating materials already collected by the IO, lordship.
My submission is that, my lord, keeping the petitioner in jail, my lord, keeping them cannot be kept indefinite period, my lord. Bail is not but equitable, my lord. My lord, he will be deprived from the fair trial, my lord, and he has to defend, my lord, this case. He has to defend. My lord.
And why are you saying that Shahanur is the main accused?
My lord, FIR, your lordship,
Main allegations are against whom?
only allegation against the Shahanur Islam. Shahanur Islam.
Sahanur, lordship, called the victim and took him along with him.
Yes.
Since then, he was, my lord, he was missing. His mobile was switched off. But all the accused person, lordship, broadly killed him, lordship.
My lord,
My lord, I have taken one of the son of the one who accused, lordship.
All have assaulted.
Yes, yes, all have, my lord, together they killed him.
But this is the statement of co-accused.
Co-accused, lordship.
Yes,
But at this stage,
yes,
lordship, we have to, my lord, at this stage, lordship. At
That
this
is
stage,
the
we have to
statement
see
of
whether
co-accused.
there are prima facie material or not, lordship.
No, no. At this stage, we have to see whether their detention is necessary for
Yes,
trial.
my lord.
My lord,
When
that is
one-
also, lordship, then such that case, lordship, we have to consider his bail application on merit, lordship, then. Because after collecting material, lordship, police has
My lord.
submitted charge sheet, lordship.
My lord, in the FIR, my lord, Shahanur Islam picked up the deceased victim, my lord, by his own car from his home, my lord. There is no whisper in the FIR about the petitioner, present petitioner. And he is behind the bar 140 days, my lord. Prime Acus already granted the bail. He has to defend his case. He will face the trial. Bail is not the equitable, my lord. He will face the trial, my lord. And if not granted, but he will deprive from fair trial, my lord. And
Mr.
R. Islam.
R. Islam, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Nobir Hussain, alias Nabir Hussain, who has been detained behind the bar since
12/7.
12/7/2023, within bracket for last 140 days in connection with
Jogi Kumar PS case number.
sessions case. What is the
Yes,
session?
session case 53, my lord. 53J.
In connection with sessions case number
53J.
53J
J. 2023.
/2023, corresponding to Yogi Gopa PS case number 189/2023, pending before the Court of London,
Additional session judge,
additional sessions judge,
South Salmara of Ovair.
South Salmara of Haifuri. The brief of this case is that on the basis of an FIR which was filed by one Shahera Khatun on 2/7/2023 is before the officer in charge of Yogigoppa Police Station, inter alia, alleging that one Sahanur Islam had called her husband on 30/6/2023, and thereafter he was not, thereafter he went missing and his phone was also found switch off. And later on, the dead body of the husband of the first informant was found from where it was found.
Obhaiburi Milan. Borkola.
Found at Borkola
Yes, Obhaiburi.
within bracket of Hairput. Stop. On receipt of this said FIR, Yogigoppa PS case number 189/23 was registered and an investigation was initiated. On completion of the investigation, charge sheet was laid against 4 numbers of accused persons, including the present petitioner. During the pendency of the investigation, the present petitioner was arrested on 12/7 and 12/7/2022. 23, and he has been detained behind the bar since then. Learned counsel for the petitioner has submitted that the case of the petitioner has been committed to the Court of Learned Additional Sessions Judge
Within bracket FTC vendor. FTC, not
FTC.
Salmara, Obhaiburi.
North Salmara, Abhayapuri, and it is fixed at the stage of furnishing of copies.
Yes.
It is also submitted by learned counsel for the petitioner that in the meanwhile, one of the co-accused, namely Shahanur Islam, who has been named in the FIR, has been granted bail
Pascal judicial mistake.
by learned judicial magistrate, learned subdivisional magistrate, North Salmara, Abhayapuri. It is in the court of which court? In additional session judge?
Additional session judge, not Salmara. Additional session judge FTC, not Salmara.
North Salmara, Abhayapuri. Stop. On completion of the statutory period of petition. Learned counsel for the petitioner has submitted that when one of the co-accused has already been released on bail, no justification is there to keep the present petitioner behind the bar when he is ready to face the trial.
Yes.
On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that there are sufficient incriminating material against the present petitioner in this case, and to show that he along with other co-accused have caused the death of the son of the first informant. Stop. I have considered the submissions made by learned counsel for both the parties and have perused the materials available on record, including the scanned copy of the case record which was called for in connection with this. It appears that out of 4 accused persons who have been charge sheeted in this case. One of the co-accused, namely Shahnur Islam, who was named in the affair, has already been granted bail.
No, he got only default bail, Lord. I'm sorry,
No.
Lord. He got only default bail because the
That I have
Sarset
mentioned.
could not be submitted in. And Lordship may kindly peruse the page number 31, Lordship. How the investigation procedure, Lordship. It is not that, Lordship, that it is only basis on the basis of the co-accused statement, Lordship, they were arrested, my Lord. My Lord, page
Please.
number 31, Lordship may peruse, my Lord, fourth paragraph, Lordship, middle portion, Lordship. My Lord, I am reading the middle portion.
Yeah.
Of page number 31, paragraph 4. My Lord, accordingly, the same vehicle was inspected by the forensics team and found suspected blood stain and hair samples in the vehicle. But this is the vehicle of Shahnur, wherein all the accused persons together committed the murder, Lordship. In the meantime, the other co-accused person, Nibir Hussain, son of so-and-so, was arrested in connection with the case. During interrogation, he
No.
confessed.
My query is when one of the co-accused is outside.
Well, outside, he has been granted bail, granted default bail, Lordship.
No, for whatsoever reason. So how long you will detain?
No, my Lord, let the search be framed, Lordship, at least, because there are every chance that they will detain the witnesses, Lordship. They will hamper the investigation.
No, my lord.
No, definitely they will do, Lordship.
How the witness
They
will
are
be
criminal,
hampered, my
Lordship.
lord?
At
Such
this stage,
a
Lordship,
case,
I am
my lord.
opposing, Lordship.
And there are 20 prosecution witnesses, my lord. It will be take more time, my lord. There is no prospectus of immediate concluding the
If
trial.
the, my Lord, main accused has been granted bail by the court below, my Lord, on merit, that I had nothing to submit, Lordship.
There is, Shahnur
He has
Islam
been
is
only
the fourth person.
granted default bail, Lordship.
People, whatever
Default
maybe,
bail is
my lord, this
totally
a bail,
different,
my
Lordship,
lord.
because it is the could not be completed the investigation within time. That's why he has been granted default bail, Lordship.
That is the lack of the investigation authority, my lord. And there are 20
At
prosecution
this stage,
witnesses,
Lordship,
my
I am
lord.
opposing, Lordship, because my Lord, there are already metal collected,
They deserve
Lordship,
bail, my lord.
and Lordship has to consider their bail application on the basis of merit, because it is search-sheeted case, Lordship.
What other materials are there to show that they would?
My Lord, because they are the, my Lord, locality of the same village, Lordship. They know the witnesses. They will definitely hamper in the investigation, Lordship. They will threaten the witnesses, Lordship. At this stage, I am opposing, Lordship.
That the BKL belongs to the Shahnur Islam, my lord. He
No,
picked up.
apart from your submission that they would threaten the witnesses.
Yes.
What materials are there to show that they have attempted to threaten?
My Lord, they have
attempted to threaten any of the
Yes.
witnesses.
But-
Who are the witnesses?
Witnesses, Lordship may kindly peruse, my
From
Lord.
the record, it is nothing demonstrated that petition are treated by any witnesses.
My Lord, Lordship may kindly see the paragraph, page number 23. This is the search sheet, Lordship, wherein the name of the witnesses, particulars of the witnesses have been mentioned.
Page number?
Page number 26 of the search sheet. My Lord, first, my Lord, witness number 1, she is the village of the resident of Jogi Gopa. Witness number 2, Jogi Gopa. Witness number 3, Jogi Gopa. Witness number 4, Jogi Gopa. Witness number 5, Lordship, Jogi Gopa. My Lord, they are all, my Lord, of the same village, Lordship.
Nearby residency, my lord, is not proof that he will be threatened, my lord.
Well, at this stage, I am opposing, Lordship. I am not submitting that, Lordship. They should not be granted bail at any manner, Lordship.
Okay. What was the last line? Last line. Before that, put one line. Learned additional public law prosecutor has also opposed the grant of bail to the present petitioner at this stage on the ground that there is a probability of the petitioner threatening the witnesses if he is released on bail at this stage, as the most of the witnesses hails from the same village from where the present petitioner belongs. Stop. Now, Lord. I'm putting condition
Yes, my lord. Any condition, my lord.
granted bail. Has already been granted bail, hence keeping the present petitioners detained during the pendency of the trial does not. This court, hence keeping the present petitioner behind the bar when one of the co-accused has already been enlarged on bail does not appear to be justified if otherwise the petitioner cooperates in his trial. As regards the submission of learned additional public prosecutor that there is a probability of the present petitioner retaining the witnesses as there is no material on record to show at this stage that he has ever retained any of the witnesses. This concern may be addressed by imposing sufficient condition on the petitioner while granting him bail so that he may not retain any of the witnesses during the pendency of the trial. So, in view of above, the petitioner, namely Nobir Hussain alias Nabir Hussain is allowed to go on bail of rupees 50,000 with two suitable purity of like amount to the satisfaction of learned additional sessions judge within bracket FTC.
North Salmara,
North
Abhay.
Salmara, Abhayapuri, with following conditions. What conditions may be imposed? Let him appear before the petitioner.
No,
following
my lord,
conditions.
he is there, lordship. So, my lord, main, my lord, question is that whether he will hamper in the trial, lordship. That is my submission, lordship.
Okay.
And there are all chances that, my lord, they will all, because one main accused person, he has been granted default bail. This person has been released today. Then other two persons also will be released after tomorrow, lordship.
The petitioner shall appear before the officer in charge of Jogigopa PS police station.
That may not be required, lordship, because the certificate case, lordship.
No, only to see that they have not done. If some wrong thing is,
Yes.
if they report to police every 15 days. Not for the investigation. Officer in charge of Jogigopa police station every 15 days during the pendency of the trial. During the pendency of the trial or till learned trial court deems it fit to continue the appearance of the petitioner before the officer in charge of Jogigopa police station. The office staff who shall maintain a attendance register to record the attendance of the petitioner whenever he appears before the officer in charge of Jogigopa police station. The petitioner shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses or to any other person who may be acquainted with the facts of the case so as to dissuade such witness / person to depose against the petitioner in the pending trial against the present petition. In sessions case number
53 within bracket J,
53 within bracket J,
oblique 2020.
2020. Number 3, learned trial court may impose any additional condition of bail if it deems fit to do so. So, any violation of the above condition may be a good ground for cancellation of bail by the London trial court without again approaching this court. With above observation, this bail application.
Deeply obliged.
32.
May please, Your Lordship. 439 bail application, my lord, and as on today, 42 days behind bars, my lord. FIR is at page number 13, my lord. CD is called for and perhaps CD is available.
Case diary is good.
What is the allegation?
Allegations is carrying fake notes, my lord, fake currencies, my lord.
42 days.
An investigation is very much progress, my lord, and the forwarding report and the order passed by the learned court below, my lord, indicated that. I have annexed all those, my lord. Kindly have a look at page number, my lord, 28, my lord. This is the forwarding report, my lord, by which I was forwarded before the learned court below after completing my police remand, my lord. 28, my lord, page number. And 29 is the, my lord, relevant portion, my lord, in page number 29, my lord. And during his remand period, the accused person has disclosed many important facts in connection with the case. He is medically examined after every 24 hours and feed the daily meal. And on that forwarding, my lord, the learned court below has passed the order, my lord, which is at page number 31. And the relevant portion is at page number 32, my lord. IO of the case has submitted that no further police custody is required and pray to remand the accused person to judicial custody. It is correct, my lord. The fake currency is recovered from me, but I am an employee of a person. FIR also disclosed that, my lord, and my employer has asked me to bring those notes, my lord. But I don't know whether this is a fake currency or not, because said me to go somewhere wherein other persons take the money which he broke from that person, my lord.
Yes.
That is the fact, my
What
lord.
is the progress?
My lord, 71,800 fake currency note was recovered from this my lord Azibur Rahman lordship. And this my lord fake currency was given by one Mohidul.
He is
Mohidul
my employer, my
to give to some third person lordship. And in lieu of that, my lord, they will get 24,000 rupees. Now, lordship, this Mohidul, he was my lord yet to be arrested. Lordship.
He is my employer.
And my lord, fake currency note, my lord, the FSL report is not received. So today is my lord 42 days. Lordship, may I pay that my lord FSL report? Maybe call for lordship. That is already been not in the case diary. And this main accused person, he is yet to arrest.
Mohidul, actually his name is Mofidul Islam, my lord. And he is my employer, my lord. And I am working in his house, looking after his fisheries and my lord, kettles and other works, my lord. So as per direction.
No, whether his detention would be.
Because co-accused is yet to be arrested.
My lord, for arresting co-accused person, may perhaps.
He is the main accused, lord, because where from there, my lord, they obtained the my lord fake currency note. How did it was my lord procured? Whether they manufactured it or not, my lord.
No, whether that is found out during investigation.
That is not been able to, my lord, because only, my lord, he has been arrested, lord. The police is trying to, my lord, arrest the main accused person, lord.
But for that, my police remand is necessary, but the police, it stated that no further custody and detention is necessary, my lord. In this instance, even after I got the bail, I can cooperate, my lord, under any conditions, my lord.
He can cooperate, lord, but the main accused person, lord,
but
it will be, if he is released on bail, it will be difficult for the investigating officer to arrest the main accused person, lord.
How can, my lord, I don't understand, my lord.
That will be
Because,
difficult.
the main accused, my employer is a resident of that place, my lord. Is not a person whose identity and whose residence is not known to the police, my lord.
No, how his release will affect.
No,
the
because,
arrest.
my lord, he will try to, my lord, help the main accused person, lordship. If there is something else, this accused person, he will definitely help the other accused person, lordship. Because the arrest of the main accused person is necessary, lordship.
I understand, but
I am not saying that, Lordship, by putting him, my lord, for indefinite period, my lord, police will keep on searching the main accused person. At this stage, Lordship, I am opposing, Lordship.
Sir. M.I.I. Hussain. M.A.I. Hussain. Learned counsel for the petition. Also heard Mr. R.J. Borwa, an additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Azizur Rahman, who was arrested on 18/10/2023 in connection with Hing PS case number 192/23 under section 120B/470/420/489A, 489B/489C/489E of the Indian Penal Code. The gist of accusation against the present petitioner is that on 18/10/2023, one Madhurjo Pegu, SI of police, lodged an FIR before the officer in charge of Hing police station, inter alia, alleging that on receipt of reliable information regarding dealing of some person in Besamari, Magurmari area under Ahomgaon police force of Hing police station in dealing with fake Indian currency note. A search operation was conducted in Magurmari area, and one person was apprehended who was found coming in a suspicious manner. The apprehended person is the present petitioner Azizur Rahman, and on search of the petitioner, fake Indian currency notes amounting to rupees 71,800 were recovered. He was found only in possession of the fake.
My lord.
Yes.
Possession is offense under. What is the punishment? Possession of. Possession of the present. What is your submission, Mr.?
My lord, my submission is that I am an employee of Mokidul Islam, my lord, and I work.
My lord, that is 60 days of penalty. It will, my lord, regarding possession, Lordship,
60 days of
60 days of penalty.
Senate counsel for the petitioner submits that he is an employee of one Mokidul Islam who had asked him to carry
some money to give someone at Alhamdulillah Bazar, my lord.
some money, and he was carrying the said money without knowing the said to be fake Indian currency.
And when I was there.
Stop. On the other hand, an additional public prosecutor has produced the case diary of Hing PS case number 192/23 and has opposed the grant of bail to the present petitioner on the ground that the fake Indian currency notes were seized from the possession of the present petitioner and sufficient incriminating materials are there to indicate that. He has also submitted that the one of the main co-accused, namely
My lord, Mohidul Lordship.
Mohidul Islam, is yet to be arrested, and release of the present petitioner at this stage would hamper the arrest of the co-accused, would hamper the process of arrest of the co-accused.
And he will indulge in same activity again, Lord.
And there is a probability of the accused getting involved, getting involved in the same activity. I have considered the submissions made by Learned Counsel for both the sides. And peruse the materials on record, including the case diary of Dhing PS case number 192/2020. It appears from record that the statement of the present petitioner has been recorded under section 161 CR. And the Caesar witnesses are also recorded.
My lord, examine and recorded. Lord.
And the statement of Caesar witnesses have also been recorded. Further, it also appears from record that while forwarding the present petitioner after police remand to the concerned judicial magistrate, the investigating officer had observed that his further custodial detention was not necessary for the sake of investigation. Further, considering the fact that the petitioner has already been detained behind the bar since last 42 days, this court is of considered opinion that his further custodial detention may not be necessary for fair completion of the investigation of Dhing PS case number 192/20. In view of above, the petitioner, namely Azizur Rahman, is hereby allowed to go on bail of 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Nagaon with following conditions. Condition number 1 and 2. Number 3 also, that the petitioner shall appear before the investigating officer of Dhing PS case number 192/2023 as and when so required by the investigating officer for the sake of fair completion of the investigation. With above observation, this bail application is thereby disposed of. Send back the case.
33,
Please, Your Lordship. 439 application. Today it is 34 days behind the bar. The allegation is under section 325, 306 and 34 of IPC, Lordship. Lordship, FIR is on page 12, Lordship.
Who has died?
Lordship, deceased is son-in-law of petitioner number 2.
Son-in-law.
He died.
Ghanshyam Bush.
And who is petitioner number 1?
His brother-in-law of the deceased.
Okay, what is the allegation?
Lordship, allegation is that the deceased went to the house to bring his wife back. It was a matrimonial dispute between the deceased and his wife. Then after that, there was an altercation between Nobozoti Das, petitioner number 1, brother-in-law of the deceased, and between the deceased. After that, the deceased went to medical. Then he went to police station, which has been specifically mentioned in the FIR, Lordship. After that, he went missing, and the family member of the deceased found a shoe near the Brahmaputra bridge, Lordship.
Whether dead body has been found?
Yes, dead body has been found.
This is my lord.
34 days.
This is my lord. He went to my lord matrimonial house to bring his wife, Lordship, along with son. Then on the way, Lordship, there is some quarrel took place. Then my lord,
with wife,
this accused person Lordship, along with another, they assaulted. But although the injury are simple in nature, Lordship, later on coming home, Lordship, the disease was, my lord, no, this Ghanshyam Das, he was missing, Lordship, and later on his dead body was recovered. Lordship. And my lord, as part of postmortem report, Lordship, this is death was due to asphyxia following drowning during life. Lordship. Direct, मतलब no such मतलब direct materials under section 306 IPC.
Heard Mr. D.
D.
Medhi, Learned Counsel for the petitioner. Also heard Mr. R.J. Bourbon, Learned Additional for the prosecutor. This application under section 439 of the CRPC of the Code of Criminal Procedure from 1973 has been filed by the petitioners, namely Navojyoti Das and
Leela Das.
Srimati Leela Das, who are detained behind the bar since 26/10/2023 and 27/10/2023 respectively, in connection with Ajara PS case number 223/2023 under section 325/306/34 of the Indian. The gist of accusation against the present petitioners is that on
25.
5/10/2023, one Shri Pankaj Bashya had lodged an FIR before the officer in charge of Ajara police station, Inter area, alleging that his brother Ghanshyam Das had committed suicide. And it is suspected that he committed suicide due to the mental torture perpetrated on him by the mother-in-law and brother-in-law, by his mother-in-law and brother-in-law, namely the present petitioner. And the counsel for the petitioner has submitted that the petitioners are not involved in any manner in the offense which has been alleged against them in the FIR. In fact, it is submitted that in fact the petitioner had matrimonial dispute with his wife, who is the sister of the petitioner number 1 and the daughter of the petitioner number 2. And on the date of alleged offense, the deceased, after going to the police station, after reporting at the police station, went missing, and later on his dead body was found in the river. Which river? Found in river. Brahmaputra. On the other hand, Learned Additional Public Prosecutor has produced the case diary of Ajara PS case number 223/23 and has submitted that from the materials available in the case that it appears that this is a case of suicide by drowning, as suggested in the post-mortem examination. He also submits that the investigating officer has already recorded the statement of relief under section 161 of the Code of Criminal Procedure. So, considering the, I have considered the submissions made by the counsel from both sides and have perused the material on record, including the case diary of Ajara PS case number 223/2023. So, considering the progress made in the investigation, as well as fact that the petition petitioners, both the petitioners are detained behind the bar since last 34 days. As well as considering the nature of material available against them indicates that their further custodial detention does not appear to be necessary for fair completion of investigation of other appeals but 2 to 3 stop in view of above, both the above named petitioners. Now both the petitioners, namely Navajyoti Das and Srimati Leela Das, are hereby allowed to go on bail of 30,000 each with one surety of like amount to be satisfaction. Done at Chief Judicial Magistrate Kamrup with
Obligement. Hello.
34.
May I please your lordship? 439 application lordship.
Charges submitted lordship.
Yes, submit.
My lord.
55 days in custody lordship. The law papers lordship. The victim was one day up with the present petitioner lordship. Go before trial. Heard Mr. Keith counsel for the also heard Mr. R.K. Burra, petitioner for submission. Though the case diary was called for output, but that it has been there in statute number
437 public 2023 dated 26/11/2023.
in view of laying of the charge sheet. In this case, this bail application is thereby because of an observation that the petitioner may approach the trial court / committal court and may pray for bail before that court, may pray for regular bail before that court, if so.
Now, lord.
35.
No, 35 and 30 lordship, arising out of the same police station case. 32 pass over timing.
Okay, we will take up 35.
My lord, 35 may be taken.
The allegation of 395 lordship, that the allegation is lordship will finally come to the
395
lordship. Case 9 lordship is the FIR copy. Trying to lordship nature of lordship 425 bags of Erica nut from a vehicle lordship by tying the driver and looted 382 bags of Erica nut. And this is their case lordship, they have been arrested and today is a 49 days.
There are material lordship, and out of the my lord 420 bag of Erica nut lordship, only 247 bags able to recover and seize lordship. Other my lord bags are yet to be recovered, and my lord, at this time I am opposing lordship. Let police complete the investigation. And there are my lord sufficient material already collected by the investigating officer against all the accused persons lordship. No, no, dokaiti lordship. Illegal kotha nahi, dokaiti case.
Considering the length of detention, otherwise I am not made it of the case lordship. Considering the 49 days lordship. What recovery has been made lordship, we are behind the bar lordship, the recovery cannot be made lordship because we are already inside lordship. And what has been recovered lordship, that was
whether driver and handyman will assault.
Yes, assaulted.
They suffered injury.
Yes.
What?
But that's not class my lord major injury, but they were my lord put in a different vehicle. They were kept inside the vehicle lordship when we assaulted.
Considering the length of detention, lordship, with a local person, no sense of absconding lordship. Their local person will appear lordship as stringent condition may be given, will visit everyday police station lordship.
Otherwise, what is the progress?
Progress Lordship to my lord arrest some other accused person and to recover the other Erika Nath Lordship. Because out of 425 my lord, only 247 bags were my lord recovered.
So all were not able, Lordship, 328 bag, Lordship, as per the FI, Lordship, 382, Lordship.
The police is my lord
Two-
searching for the other accused
380.
person. Lord.
That, Lordship, that
That
keeping
is the
behind
last
us, Lordship,
entry of the Lord case there.
will appeal, Lordship, each and every, Lordship, as this honorable court, Lordship, stringent one.
You will appear each day.
Whatever, Lordship,
Then I will put such condition.
Lordship may put. Till the charge sheet file, Lordship, or the ways and when the IO direct us to APL. Lordship. We are from Assam itself, but local person.
That is why Lordship, they have got all the information. Lordship.
Keeping behind, Lordship, for another days, Lordship, that will not have the purpose, Lordship, because what investigation was there already done in our part, Lordship, that might have been completed.
Heard Mr. S. Moni, learned counsel for the petitioner. Also heard Mr. Rati Gogol, additional purpose. This application section 439 Code of has been filed by the petitioners. Where the case is investigated, in which police station?
This is Porpeta, Lord.
Some of you are from
Sorvok, sorry, Lordship, Sorvok.
some of you are from Kamrup.
Lordship. Two are from Borpeta, Lordship, three are from Kamrup. As any condition, Lordship. As and when the directed, Lordship will appear. Otherwise, if a ground for cancellation of our pay.
But it will, my lord, it will be difficult to my lord recover the remaining bags. Lordship.
Keeping behind us, Lordship.
Because they know where they have sold it or where they have kept it. Lordship.
That they have to take us in custody, Lordship. That is initial point of time, Lordship, when arrested, that has been done, Lordship. Further keeping in jail, Lordship,
My objection may be recorded.
Lordship.
Lordship.
Automatically, police cannot recover.
Namely, when so name of the right person who are detained behind the bar since 10/11/2023 in bracket for last 49 days in connection with Sarmok PS case. Sarmok PS case 107/2023 under section 340/395/412/413 of the case. The list of accusation against the present petition that on 5/10/2023, one Kailash Mandal had lodged an FIR before the officer in charge of Orbok Police Station, inter alia, alleging that on 4/10/2023, when the petitioner, when one truck bearing registration number RJ21803892 was carrying 425 numbers of bags of areca nut. Some of the unknown miscreants stopped the said truck and by threatening and assaulting the driver and handyman of the said truck, they looted 382 bags of areca nut. And counsel for the petitioner submitted that. What is the maximum punishment? 395?
Live.
Right. Submitted that the petitioners are detained behind the bar since last 49 days and considering the period of detention they may be allowed to go. On the other hand, an additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that only 247 bags out of the stolen 382 bags of the areca have been recovered. And some of the stolen areca nuts are yet to be. It is further submitted that some of the co-accused are also yet to be apprehended by police, and release of the accused at this stage. Release of the petitioner at this stage of the investigation would hamper in the investigation of the case, as well as the recovery of its remaining stolen property. I have considered the submission made by the both the sides and have perused the materials on record, including the case diary of Turbo case 107/2020. Appears from case diary that though some of the stolen areca nuts are yet to be recovered and some of the co-accused are yet to be arrested. However, otherwise the investigation has failed progress. It also appears that the petitioners have already been detained behind the bar since last 49 days, and in the considered opinion of the court, their further custody may not be necessary for fair completion of the investigation if they otherwise cooperate with the investigating officer. In view of above, the above named petitioners are hereby allowed to go on bail of rupees 30,000 each with one security of like amount to the satisfaction of learned
CGM Barpeta.
judicial
Mr.
Barpeta with following conditions. Condition number 1. Number 3, they shall appear before the investigating officer or case list number 107/2023 as and when required by the investigating officer for the purpose of fair investigation. They shall also provide, number 4, they shall also provide their contact details, including the telephone number, mobile number, and residential address to the investigating officer with above observation. This bail application is hereby sent back.
Much obliged, sir. Much obliged. Much.
And take one. Judgment. It appears from record that the incident occurred in the month of August this year, and though there are incriminating material right now, as the petitioner has complied with the directives of this court and has cooperated in investigation, his custodial detention does not appear to be necessary for fair completion investigation of Lahori Ghat case number 221/2023 if he continues to cooperate in the investigation. In view of above, the interim anticipatory bail granted to the present petitioner by order dated 14/9/2023 is hereby made absent with following conditions. Condition number 1. Send back the case.
41.
May please admit.
Well, case diary was called for.
Case diary not developed.
You are on interim.
Yes.
Heard Mr. N03, the council. So heard Mr. R.J. Brodwell, done a petition for who prays for some more time for producing the case file. If prayer is allowed, let this case be listed again on
8/12.
8/12. The interim order that got.
I'm glad.
42.
Happy. Your Lordship, SPP is supposed to obtain certain instructions from the IO. Whether it's custodial interrogation.
Lordship, a report was sought for regarding custody interrogation of the present petitioner. That report we have not received.
Whether telephonic information.
Yes, we have already intimated that they're supposed to give us today itself, but not yet we have received.
We'll take it up. No written report is required.
Lordship, only verbal instruction.
Even if the IO verbally inform it, because this
Lordship.
is a case of 2015.
Yes,
Yes, sir.
so tomorrow, Lordship,
Your Lordship, last two occasions, same thing has happened.
Okay, let us see tomorrow.
Lordship.
Heard Mr. S. Dekar, done it counsel for the. Also heard Ms. S. H. Bora, done an additional public prosecutor, who prays for some more time for seeking necessary instruction from investigating officer as directed by this court by order dated 22/11/2022. Where is allowed. Let this matter be listed again on 30/11.
Lordship.
Obliged.
43.
May it please your lord. My lord, I pray that your lordship will look into the order dated 3/10/23. You are appealing for? For me. Manager. Manager. Yes, I will file. Manager. As regards, my lord, today I have got an information. The manager, my lord, a case has been registered against the manager. He is the main culprit. My lord. This is his case. His case has been registered under section.
What was the case again?
My lord, against me, the case is that, my lord, in some account was debited and the amount was credited in my account, and I have sent a legal notice. That is my main allegation against. And against the branch manager, my lord, today I have gotten a case 272. Manager? Manager, certificate. And I have given my statement of as per the direction of.
No, what was the acquisition?
Acquisition in the FIR is that page, my lord. Start that page. $19.
JLG agent means
My lord.
JLG.
JLG, my lord, some kind of a daily based agent to collect money. That is not me. I am, my lord, I am the Azizur Rahman Lashkar, in whose account, my lord, it has been created.
How much amount? 7 lakhs.
7 lakhs.
Thereafter?
Thereafter, my lord, they have stated that I have withdrawn the amount. But the records in the bank, they themselves have said is not available. It is in their affair they have stated, my lord, the documents are not available in the bank. How it was debited somebody's account, how it was credited. And the main person who was that Fakhrul Islam Barbhaiya. Joint liability group in agent. I've given my statement also.
And you are not aware of the fact that
That it was created. Because I am a businessman. Other account, how it has been created, who has given my account, that I am not concerned about. But the allegation in the FIR is against.
no, but you are not aware of. So, amount coming to your.
Because I am a businessman, not different accounts, different amount come in my account.
Okay.
From business. I am a business.
Yes.
And in the legal notice, they have stated, my lord, that surprisingly, instead of cooperation, he sent a legal notice dated, putting the notice receiver in fear to deliver such and such. And they themselves the staff themselves has returned the money to the person whose account has been debited. They themselves.
Bank officials.
Bank officials, they have themselves. And now we have come to know the bank manager against bank manager, my lord, the case has been registered. Received,
The bank manager who lost FIR against you.
Maybe this is the
Because your FIR was against.
branch manager, and the branch manager, he himself is.
No. I just want to understand.
The branch
The
manager
FIR against you was lodged
by
by
the branch
bank
manager.
branch manager.
And the man whose account was debited has lost the case against the branch manager.
The person who lodged against FIR against you, he has also been made an accused.
Accused by the person whose account was debited.
Okay. But he got back the money.
He got back the money from the bank office.
Okay. Yes.
And this is a whole conspiracy between the officials. How could they lose that?
You are for the informant.
My acknowledgement is appearing for the informant.
Informant branch manager.
Yes, informant branch manager.
Now an FIR has been lodged against you also.
Fingerprint is saying, I don't have the.
This is a certified copy.
No, that may be, whatever the merit of the case against me, that will be decided in the instant that relevant proceeding. That is not the subject matter now before your lordship.
Now, why are you opposing?
We are opposing, my lord. Lordship will take up kindly my objection. It is at page 20, running page 26. But this is it. So this is a very interesting case in which the petitioner himself, the beneficiary of a financial transaction, is saying, I do not know, 7,30,000 entered my bank account. I do not know from where I received it, but I will keep it because I do not know from where I received it. Lord, what statement he has given, my lord, I do not know.
Under the provision of CRPC,
I did not interrupt, my lord. I did not
under the
interrupt,
provision
my
of
lord.
CRPC, he cannot speak, my lord. Under the provision of CRPC, he can only.
I can speak only with the permission of the court.
My lord,
Subject, if your lordship
CRPC
does not
does not
allow me,
provide him
I will sit
to
down.
object directly.
I am ready to assist the learned PP. I have filed my objection. Lordship will see my objection and pass.
He is objecting as like he is a PP, man.
Lord,
he cannot do it, man.
I have placed my
No,
objection on record.
he can assist the
I can assist that. Let the PP submit. I have no. I'm not asking any.
But court can allow him to.
Yes.
Court can allow.
So 302 is for trial, my lord, not for the bail applications. And I did not interrupt my learned senior friend. Lordship will kindly turn, my lord.
You can object with full vigor.
Lordship. The Lordship will see what kind of a case this is. My lord. There were three named
No, but
persons.
I just want to know when the petitioner has appeared.
Lordship.
When he is cooperating in investigation. When
But I am not privy to what statement he has given to the IO.
What is the ground of your objection?
My lord, in this case, what has happened is.
Yes.
Yes, what has happened is, I have shown that he is the beneficiary of the transaction of 7,30,000 rupees. My lord, there are three named persons in the FIR. One of the first FIR named person is Abdul Monnan Hazari. The second is Fakhrul Islam Barbhaiya, and the third is this petitioner. Now the money went from the account of this Huzuri, who now my learned senior friend is saying that has lodged an FIR against me. That may well be so, my lord. He has every right to file FIR. Huzuri's account, from Huzuri's account, 7,30,000 was transferred to the account of the petitioner.
Who has transferred?
You know, that is the crux of the question. Now, the bank lodged an FIR that Fakhrul Islam Barbhaiya, who was a joint liability group agent, he conspired with this Huzuri and this petitioner to transfer this account. Now, after more than 1 month of the transaction, Huzuri comes to the bank and says that I am not aware of this transaction. I have not made any RTGS payment. After 1 month. And when the bank said that, oh, all right, we were checking up, on the next day he comes again. When the RTGS slip is not found, then the suspicion falls on Pokhrul. Now, Pokhrul and
No, I want to question.
yes,
Who can make RTGS?
the account holder,
Only the account holder.
only the account holder.
Then
So Huzuri says
he
that
is not the account holder.
he is not the account holder. I'm not. It is not the case that he is account holder, but the money, my lord, 7,30,000 has gone to him.
Maybe.
He is saying that I do not know. If he does not know, then he should explain where this money has come from.
Who
He is
is
not
he to ask me? Madam? Who is he to ask?
because it is my money.
No,
Because my officers have
my
have
money,
refunded
bank
me.
money.
Well, my money, bank money, he cannot say. Madam. This transaction has
It
been
is
debited from our
between
account.
Abdul
Again,
Mannan,
I
Hazari
did
and
not
Lashkar.
interrupt the learned senior. Madam.
No,
He argues or I.
Between Hazari and Lashkar.
No, Mr. Rochester.
Madam, let him speak.
This is
That's
not
all
a-
right, I'm not.
He has every opportunity. He will rebut.
First of all, this is not a civil suit.
No, it's not a civil suit.
I am concerned only with the progress of investigation.
Yes. Yes.
So whether his
Yes.
objection
If
is
my objection is not
relevant,
valid, if your my objection is not,
if
Lordship
I
will-
do not
will-
find it relevant,
will convert. Now, Your Honor, when this matter, one of the agent, the High Court, the coordinate bench of this court has rejected the bail of Fakhrul Islam Barbuya, who is the agent, after producing the materials in the case diary. Lordships have it, Madam? Page 34. By this application, you see the petitioners, namely so and so, seeking pre-arrest bail in connection with Hailakandi PS case number so and so. Case diary has been called for, and after perusal of the same, it is found that there are sufficient incriminating materials against the petitioner. Therefore, in the considered opinion of this court, this is not a fit case where the privilege of pre-arrest bail should be granted to the petitioner. Accordingly, this application for pre-arrest bail stands rejected. This is
Fakhrul and the present petitioner
Fakhrul.
stands on different footing.
Fakhrul and present petitioner stands on equal footing, but Your Lordship, I would say that petitioner should be in a worse position because he is the beneficiary, and till date he has offered no explanation as to where this money, how he was entitled to the money. Because Your Honor will see that if this is right that FIR has been registered against me by Huzuri, the person from whose account was the amount was transferred. Your Honor, Huzuri says I did not transfer it to Azizur Rahman, the petitioner. Then how could he be entitled to the money? There has to be a conspiracy. This conspiracy has to be investigated. And other than these three persons, it is very difficult to see how anybody else is involved. Because, Your Honor, if an amount of money, even 1 rupee or 1 crore, it may come into my account or anybody's account. I may not know about this transaction. But once I retain that money without any justifiable explanation, saying that I am a big businessman, so I do not know, 7,30,000 comes into my account every day. But
No,
Your
if
Honor,
it
this
is-
this amount came to him on 21st of July, 2023.
Then he has to return back the
And
My lord.
today, if I may be allowed to come, 21st July 2023, today we are on 29 November, more than 4 months have passed. Till date, let him show how he is entitled.
My
to
lord,
it.
in short.
That he has to show not to me, but to the investigating officer.
My lord, now in
If he has
short,
shown,
what
I have
to
no
say?
case. Then I have no case. If he has shown and justified to the investigating officer after Your Lordship.
My lord,
remodel-
I want to place it in simple way. The bank now because they have paid from their own, through pressuring me, they want to get the
These
money
are
back.
not,
This is
again,
what
I
they
don't know, Malala, why
they don't
he's
have the
interrupting.
they don't have the papers.
And the
Where is
other,
the papers?
and on page 36, Your
Where are
Lordship
the
will
papers?
find the other accused, the accused who
And
has
why
now
should I
filed.
explain to the bank?
No, I
Where
don't-
are the RTG papers? They have lost the RTG papers. I don't know
Because
what
the
it is.
RTGS papers were lost, the entire case has arisen, my lord.
Why they have,
How-
why?
I assume he was also not in the branch.
It will
at
take
that
more
point of
time if you interfere.
But something is said blatantly wrong.
Whether I am right or wrong, Lordships will judge it. Lordship will kindly find that page number 36
No,
is the.
He is also an
On-
accused, my lord.
On what? So what are your main grounds? for-
My grounds are that, my lord, 3 persons were named in the FIR, Huzuri, Borbhuiya, and the petitioner. Regarding Huzuri, the bail of Abdul Mannan Huzuri has been rejected by the district court. I have given the status at page 36. That order has not been uploaded, but it has been rejected. Materials have been found against him. This, a coordinate bench of this honorable court has rejected the bail of Fakhrul, the agent, which is at page 34. Now, both these persons, along with this petitioner, were named accused in the FIR. Now, the fact remains that he is the beneficiary. It is not Hujuri who is the beneficiary. Yet his bail has also been rejected by the court. Fakrul may or may not also be the beneficiary. We do not know. But his bail has also been rejected. Apparently, my lord, there is prima facie material to show that there was some amount of coordinate planning and conspiracy between Hujuri, Fakrul, and this petitioner.
Subject matter of the investigation.
That is the subject matter of the investigation. But I have only one question, Your Honor. Whether after your lordship's interim order, when he appeared before the IO, whether he has been able to justify this transaction, because we are now into 4 months, he has not given any explanation of where this money comes from. If he is entitled to retain that money, I have no case of objection. But if he is not, then let him explain. He may not have known in 21st July, but today on 29 November, when there are criminal cases pending and he is seeking pre-arrest bail, is he not under the duty, my lord, to justify to this honorable court that how he is entitled to retain that money?
No,
That is my only case.
We are not into that question.
Your Honor, if that be so, my lord, then of course,
Because-
that is the case, because he is the beneficiary. If he is the
That
beneficiary,
is not the subject matter of the criminal investigation.
Cannot be.
Investigation is whether there was a criminal conspiracy.
yes, and to unearth that conspiracy, it has to be examined as to how he came to that, entitled to that 7 lakh 30.
To fear get the money back. And they have lost all the papers. They themselves are the manager himself is the accused, my lord. He is an accused. He is the conspirator.
He is an accused, but not in this FIR.
He is
can
an
tell you
accused.
in
Mr.
whatever.
Roy Choudhury, if money has come
I will, my lord,
without your knowledge to you have to return.
my lord, that I will do it, my lord.
But that
But
is
That
not,
will be recorded then.
that-
that is not the subject matter. of
That is,
No, then
that
that
is
that
to
has
be
to be
recorded,
considered.
my lord.
What right he has to return that money? Is it not criminal
My lord,
misappropriation
again,
per
they
se?
are after the
You are
money.
mixing up the matter.
Lord, if it be so, my lord, then let him just justify as to how
Your-
he is entitled to
your-
retain that money. Because this
Your
will
only
create, my lord,
objection is that he is retaining the money.
he has retained the money without, because, my lord, the very act of retaining the money indicates that there is a conspiracy to defraud the bank. And these people may commit further offenses also. My lord, this will encourage, my lord, terrorizing the bank officers, because I've explained in my objection and also, my lords, before the IO, as to how the bank officers have been terrorized, my lord, to pay this amount of 7 lakh 30,000 to Huzuri.
That is not to
That
me.
is there in the FIR itself.
I am not
The
there.
FIR, I am not saying about your client. The Huzuri came with, my lord, a mob on the second day. When the RTGS papers were not found, bank officers were terrorized, my lord. That's why they paid from their own account, not from the bank's funds, my lord. Why this situation is developing, my lord? Why the bank officers are being terrorized?
No, but.
And
that
how
is-
he is the beneficiary?
That is the allegation
My lord,
against Hujuri.
my lord, that allegation is there against Huzuri. But Huzuri's transaction has benefited whom, my lord? It has only benefited him, to our knowledge. Whether Fakrul was benefited
No, his
or
submission
Huzuri
is
was,
That it has been,
it has been done.
Business transaction. This is a business
If
transaction.
that is a business transaction, my lord,
That
then
I will prove
Huzuri
with
will
the trial, my lord. Not here. Not before him, my lord. Not to the bank official.
not to us, but
Not to
the
bank
IO,
official.
but to the
I will
IO
put in the
certainly.
trial whether that amount was at all my business transaction or something else. Not to the bank official. They, through a pressure, putting me in the custody, want to get the money back. They are again try to observe. They are praying before the court to observe that they will return the money. Why?
Lord-
Why are they after that? Only because, my lord, they are the conspirator. They themselves has done. Their RTJ papers have been lost by them. The manager himself is involved.
On the second
In
day
all
itself,
this,
the
my lord.
funds were returned. That is on record, my lord. And is there, my lord,
Because
a
otherwise
whisper in the bail petition that, my lord, how is
And I have
entitled to
made
the
my
money?
statement before, my lord. I am cooperating with the investigation.
That's my objection, my lord. Lordship will consider my very strong objection, take my objections on record. Here the learned PP on the material, my lord. Lordship will
Yes.
pass. Considering that, my lord, both the other named accused, bail has been rejected, one by the district judge, one by this honorable.
They are in a different footing, my lord.
Lordship, I'd like to place my submission in that, Lordship. The gist of the FIR is this: the present petitioner is a customer and account holder of Industrial Bank, and an amount of rupees around 7 lakh has been credited to his account from the account of one Abdul Mannan Hajari, who straightaway denied the fact that the RTGS was not done by him on his request. And thereafter,
Abdul Mannan Hujuri.
Hujuri,
Who is the informant?
Manager.
manager is in,
No, you are the manager.
Yeah, I'm the manager, I'm the.
and from whose account the money has been transferred to the present petitioner's account. who holding an account in IndusInd Bank.
From Hujuri's account to the petitioner.
Yes, 7 lakh has been credited, and thereafter Hujuri came to the bank and straight away denied that on his request, RTGS was not done. And thereafter, subsequently, the present petitioner sent a legal notice, that is unwarranted legal notice to the bank officials by demanding an amount of rupees 6 lakhs and something.
Present petitioner.
Yes, that is the allegation. That effort, after on lordship 3/10/2023, the petitioner has granted interim protection, and thereafter lordship, the statement has been recorded. And from the statement, it reveals that lordship, there has to be some nexus between the present petitioner and one lordship, Fakhrul Islam Borbuya, who happens to be the joint
No, what is the
liability
finding
group.
of the IO?
Lordship,
Whether IO has found any nexus?
lordship, I'm just reading his statement. The connivance, how it connected to each other, that will come up with that. So I'm just reading the
No, no,
statement.
what I want,
Lordship.
because when the petitioner was granted interim bail on 3/10,
Lordship,
thereafter he appeared.
he
before-
appeared, his statement has been recorded.
Recorded.
Yes.
Thereafter, investigation is progressing,
It is going on.
going on.
Yes.
Now, what is the what is the
Because-
finding in the investigation?
Yes, from the records, it found that the present one lordship Fakhrul Islam Borbuya, he happens to be the joint liability group who managed to deal in loans, especially in loan segment. Lordship, what happens, lordship? He used to provide loans to some members of the other after consulting with the bank authority, as well as with the help of the bank authority to collect. But what happened? Once lordship, he has given an amount of rupees, he has some deposited 8 lakhs. He has,
Fakhrul.
he has deposited 8 lakhs to Fakhrul for providing loans to other 3 members, some other people. So that money has not been repaid by Fakhrul to him,
To whom?
to the present petitioner. He has failed to repay. Then what happened? Once upon a time, this present petitioner asked Fakhrul Islam that to transfer some amount from the account of one Abdul Mannan Hajari. Once upon a time, he has asked him to.
He means
Present petitioner to ask some transfer some money from the bank of one Abdul Mannan Laskar, Hujuri lordship. And thereafter, lordship, that money has been, this petitioner in connivance with Fakhrul Islam Laskar, his money has been transferred to his account. That is admitted fact. Lordship, kindly go through the statement of the present petitioner.
you make your submission. I will go through case.
Lordship.
So
In the IO's note also, it reveals that there is some nexus between the parties who has fraudulently, that the money has been transferred from Laskar's account to his account. And the middle person is one Fakhrul Islam Borbuya, who happens to be the one agent, lordship, JLZ agent. He used to provide loans to other persons.
now what the IO has stated regarding custodial.
Lordship. The last note of the IO, it is noted that after analyze the bank statement of Azizul Rahman Laskar, it has revealed that rupees so-and-so, 7 lakhs so-and-so was transferred from the account of Abdul Mannan Hajari on so-and-so date, which was withdrawn. And the same suspected that FIR named accused are known to each other very well. They are in a very intimate terms, the present petitioner and the Fakhrul lordship. They used to talking terms in a very intimate to each other, and they together pre-planned it to extract the money by cheating the bank employees. That is the note of
No, how RTGS could be done by
some other person.
Some other person who is not holding the
lordship. That is the main.
You made RTGS.
RTGS was made by Hujuri.
Okay.
He is bank manager, my lord. He is bank.
No, please don't interfere. I'll give
There
you
was no
ample,
CCTV camera, otherwise, my lord, everything would have been.
no, I will give you ample.
My lord, I'll-
Because what has happened,
Unless I understand,
My
I
lord,
will put queries to you.
yeah, what has happened is, my lord, this is the FIR. It's elaborately and clearly mentioned. RTGS is admitted by the bank, there's no doubt. What we say is that Ujuri, because RTGS cannot be made by anybody other than the account.
Yeah.
The RTGS are, my lord, made by way of slips. My lord, these are not branches in let us say, Guwahati or any major metro. Most of the work is done by hand manually. The slips are kept. This person, my lord, this Kokrul, and these aspects were considered by the court when my lord, Kokrul's bail was rejected, so it may not be reflected in the order. So I appeared in that matter. What has happened is that Kokrul as a JLG agent has access to the interior of the bank. Because in these, my lord, these functions are always informal in nature. They come
No,
inside. So
no,
Kokrul,
before you go.
Yeah.
The present petitioner, that is present petitioner,
petitioner is my lord, Azizu.
in Azizur's account, 7 lakhs were
Yeah.
transferred through RTGS
RTGS from the account of Huzuri.
Huzuri.
And
Now my query is whether is it Huzuri who made the RTGS?
my lord, on
Because
the- on the day-
he appeared before bank and he stated that I have
Yes.
not.
Yes, he
And-
straightaway
and your
denied.
lordship will consider that the transfer was made on the 21st of July 2023. Huzuri came to the bank on 30th of August, 1 month and 9 days after the.
Yeah.
So 10.
So what
So
is your,
when any transaction beyond a certain limit is given, the bank always sends message, and he came on that day with the pretext of updating his passbook. When he came for updating his passbook, he says that I have come to know that this has been done. My lord, when we search for the RTGS slip, the RTGS slip is- However, there are the case in the FIR as well as the statement of the bank that Huzuri and Kokrul were both seen on the day of 21st. So the suspicion is that Kokrul, having access to the RTGS slip, has removed it from the bank.
but Kokrul is not your employee.
Kokrul is not an employee, but he is a JLG member. These JLG people, they are always all over the bank premises. These facts were considered as a.
No, then how Azizul is at
Because
fault?
it is not necessary for the conspirator that he will be entering the bank premise. He is the beneficiary. He is
No,
sitting in the same bank.
I
His
just,
account is
I
not in
just
my bank.
again want to understand. Somebody alleges before you, before the manager bank, that from my account, unauthorized transfer has been made.
Yeah.
Now you have find your investigation, bank's investigation says that it is the person who is alleging he actually made the RTGS transfer.
Yes. Because
Then
RTGS
where is the fault of Azizul?
So the
If,
fault of
he-
Aziz
if Huzuri himself made the transfer,
Yes.
then you are also not at fault.
So that is a matter of investigation. Whatever has been read out in the from the CD, it is clear that these three persons are known to each other. My lord, Huzuri has got back the money. Lordship will consider that. After making this allegation that I have not made the transfer, Huzuri has admittedly received back his money because two bank officials would have lost their jobs and probably would have been jailed by him. Because a mob came on the second day, accompanied by Huzuri, my lord, and Huzuri threatened to commit suicide within the bank premises if his money was not returned. When the RTGS form was not found, then my lord, two bank officials voluntarily, my lord, of their own money, not the bank's money, of their own money, 7,30,000 has been deposited in Huzuri. Huzuri has not lost anything. The only persons who have suffered are the two bank officials.
And therefore you want that Azizul should pay back the money.
Pay back the money. That is what.
If Azizul should not pay back the money, my lord, then he becomes the beneficiary of an illegal, unauthorized transfer.
How you know?
And if your lordship wants to uphold that, my lord, then
No, that is not the issue before.
may not be, my lord. But
This is a criminal
aspect
court.
of conspiracy
Here
has
the
been considered.
allegation is of criminal conspiracy.
Yes.
But your own submission is reflecting that there was no conspiracy. It is the Huzuri who himself paid back. He himself made the
Yes,
RTGS
but
transaction.
It is indeed correct that we suspect that Huzuri made that because
If
RTGS.
Huzuri made the RTGS transaction
Yeah.
for whatsoever reason to the Azizur's account, how Azizur is at fault?
Lord,
Now, if he is not repaying back this money, that is a dispute, civil dispute. And in the meanwhile, what has happened, the bank officials have paid back.
Paid, yeah.
Azizun never asked them to pay back the money.
No, Azizul didn't come to the bank.
Okay.
We approached to Azizul that you.
Now you want that Azizul should pay back the money.
No, this is not a question of our wanting.
No,
The IO,
but
as per whatever has been said.
IO is also not should not be concerned with that fact. IO should be concerned with the fact whether the allegation of
How can the
misappropriation
conspiracy-
and conspiracy.
How can the conspiracy be ascertained? If there is one beneficiary and one person says that, "Lord, I have not transferred, and yet he expect the money." But I leave it to your lordship. Considering that money.
The section 403, 409, 428 is in fact. Okay. Any more submission?
No more.
Give me the case diary. I'll go
Yes,
through
sir.
the case diary.
Yes.
Heard Mr. T.K. Roy Chaudhary, Learned Counsel for the petition. Also heard Ms. S.H. Bora, Learned Additional for the prosecutor, as well as Mr.
A. Ganguly.
A. Ganguly, Learned Counsel for the
Inform.
informant. Let this case be fixed for delivery of order on Monday. Monday,
Applies.
4th of December. Okay. I'll keep CD with me till.
Lodge.
The transaction. That being the case, if he is the beneficiary, then one can explain money coming into somebody's account as I have submitted without his knowledge. But once it is pointed out to him, and now we are well past 4 months of the transaction in question, once the money has entered, and that too not a insignificant, it is a substantial amount of money has entered his account, it is pointed out by him, rather than explaining and justifying as to how it could be. He did not justify it to us. That is not our case. But he definitely needs to justify it to the IO as to how he has come into possession of this large amount of money and what is his right to it. If he could justifiably give an explanation, because the person from whose account money is transferred, namely the Huzuri, he is saying that I have not transferred. He is saying I do not know this person, I have not transferred any money. So, prima facie, and coupled with whatever was read out by the learned people.
Otherwise, what should he do? He should return it back.
No, if he is able to produce whatever material he has to the learned, to the investigating officer, justifying that, look, this is the amount, this is why I'm entitled to it. Because otherwise there is definitely a cloud over him as it is over Fakrul and the other person. And as far as the FIR against Bank of Manager.
Otherwise, this is also one limb of your submission that it is the Hujuri himself who had done the RTGS.
That we have to presume. But since the RTGS...
No, from the bank side, you are the bank manager.
Yes, I'm the bank manager. And in the FIR, we have stated that the money indeed was transferred. But since the RTGS form itself is missing, and from the date of the transaction onwards, until the date of lodging the FIR, Fakrul Islam also went missing. So when we made search, we could not trace out the RTGS form.
Apart from RTGS form, there is no other record or no electronic record of transfer.
No, only the system is indicating that money has transferred.
From whose account to whose account?
From the account of Huzuri to the account of the petitioner. Because when this Huzuri, he came, as I said, almost 1 month, 10 days after the transaction, he came that I have to update my passbook. So when he updated the passbook, He said that, look, I don't know about this money, how it has been transferred. I never made the RTGS transaction. That is when the problem started. And on the very next day,
How RTGS transaction is done?
RTGS transaction,
By filling up a form.
for filling up a form,
Check,
and,
check.
and that
Check.
form is, yes.
So unless the check,
Yeah.
the signatures
No, it's
are
not a
for-
check. It is not called a check. It is it is in ordinary language. Let me say it's a requisition slip.
where
That
the
slip
person, account holder has to put his signature.
has to put his signature. It
So
will
it
not be
has-
any other person.
So it has to be tallied by the bank.
Yes, it has to be
Whether it-
tallied by. And that record, that slip, when we go to the bank, for example, for depositing any money, we deposit the money, the voucher is given, and the slip we keep for our purpose, for our
So
record.
the
It is in
allegation
same
is
way.
that there is some forgery of the.
There, no, there is no allegation of forgery in the FIR. The allegation is that from Huzuri's account, because the simple explanation is that we do not have the RTGS slip. But without the RTGS slip, without Huzuri's consent, no money can be transferred. So Fakrul and Huzuri were obviously in collusion with each other, and the money was transferred to the beneficiary, that is this petitioner. Now, therefore, the burden prima facie lies on him to show that how he came to be entitled, because Huzuri is saying, I have never transferred the money. If he has no right to receive the money, then he would obviously have to be investigated as a part of the conspiracy. That is what the IO seems to have discovered. And these three persons are all known to each other. And there is no whisper in the bail petition as to how he is entitled to the money. He simply says, I do not know. He may not have known on 21st July or even thereafter, but when he is applying for bail, when he has obtained an order of pre-arrest bail, when he has gone to the IO for giving statement, even then he doesn't have an explanation. So all this,
No, we'll go through his.
so all these points unerringly.
But assuming that this money has been deposited to his account without his knowledge or information by Hujuri.
Let him make a clean breast. Let him say how he's entitled to the money. I can receive in my money in my account.
Assuming that he is not entitled, but it has been wrongly deposited by Hujuri.
Yeah.
Then
Your angle, Your Honor, the angle of conspiracy between him, Fakrul, and Huzuri has to be investigated properly.
By the IO.
Yes, and the
Malad,
bail of
can I say
Huzuri
one thing?
and the bail of Huzuri and
Okay.
and the bail of Huzuri and Fakrul have already been rejected. One by the learned.
My lord, if somebody illegally deposits something in my account today, tomorrow I have a conspiracy with that man. In a small place, I am known to everybody.
Therefore, I am putting query.
My lord, another one thing, my lord, I am a regular person who do RTJ to my daughter's hostel. For RTJ, a form is required. With that, a check is to be given, because in the check we have to give the commission amount to the bank for transfer of amount.
No, in our bank, there is no such system.
Malad,
I have
without
taken
check,
the
it cannot be done.
There is no such system of checking back.
Okay.
He may do it in whatever bank, I do not know, but in our bank,
In
there is
State
no
Bank,
system of
in
check.
State Bank, my lord, it is done that way.
We are
And-
not State
And
Bank.
7
We are
lakh
Assam Gramin
rupees,
Vikas.
7 lakh rupees without a check, they are issuing in a form.
No, we are
That
doing
is
it by
total
form.
Bank
We-
is a fraud, man.
Bank, apart from the.
These type of allegation he can raise in parliament or assembly, not here.
Because,
Because
Malad,
bail
I-
petition, Malad. What is
Malad,
this?
No,
Malad,
please,
You are a political speech.
please
Malad.
answer when
Because,
I,
my lord, the bank manager is a.
Mr. Roy Chaudhary,
He has got bail. Go and object to it.
please address me.
Lordship.
Apart from the RTGS form.
Yes.
Whether bank maintain any other record of RTGS transaction? Any other record?
No, in the
Verify,
no. Apart from the RTGS form
which
and
you
the, and
you
the
are saying
computer-
that which has been lost from that
No,
RTGS.
lost
slip
it cannot be. What happens is that the form is done, the money is transferred, and the computer, the system keeps the entry. But the system will only indicate that there has been a transfer from account A to account B. It will not
But
indicate
that
anything else.
authority slip is lost.
Yes, that authority slip, the hard copy of which is maintained with the bank, that is slip. That is missing.
Apart from
Yes.
that authority slip, don't you maintain any register, anything?
No, not to my, as per my instruction, there is nothing. And that is where the role of Fakrul comes into play.
Okay. Then I have already dictated order. Instead of Monday, the judgment will be delivered on Friday, 1st of December.
My lord, only thing is this, my lord, my case is, my lord, they are saying that I am known to each other. All the 3 persons are known to each other. Somebody deposits something in my act. Then I have to rush to the bank to say, no, this is not my amount. Please take it. To whom I will return now?
You have to return it back to the person. From whom-
Let the person come to me and ask the money. Why the bank is so much eager?
Because
At least, again, my lord, now he is speaking. My lord, why the bank is so much eager?
I have understood.
My lord, the bank is there to put pressure on me to get the money what they have given, because it is their fault. They have lost the paper.
Okay, first of this.
Item 72,
I've checked with the IO, Your Lordship. That was yesterday's matter where the stipulation that was written in my file is that perhaps statement recorded. I've spoke to the IO. IO said that yes, his statement was recorded under 161.
Mr. P. Bora, learned senior counsel, assisted by Ms. K. Sharma, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor, who has submitted that as per the direction of this court, she had spoken to the investigating officer and who has informed learned additional public prosecutor that the present petitioner has appeared before the investigating officer after he was allowed to go on interim anticipatory bail, and his statement has also been recorded under section 161 of the Code of Criminal Procedure. So, in view of the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the petitioner, namely, what is the name?
Is a Mr.
Mokibul Haq.
Muhammad Mokibul Haq is by order dated 5/10/2023 is hereby made absolute with condition number 2 and 3, 2, 3 and 4 attached to the said order remaining intact. With above observation, this anticipatory bail
item 44,
Yes, that is just.
May I please? Well, in this case, on the last occasion, Your Lordship, after going by the case diary, please to grant interim bail. According to Lordship, we appear and our instruction has already been
Your Lordship, after getting interim, city was called for that we haven't received it, along with the injury report.
only medical report was called for.
In the earlier occasion, that was not available.
Case diary has not been
Not.
heard. Mr. M. Khan, learned counsel for the petitioner, also heard Ms. S. H. Bora, learned additional public prosecutor, who prays for another date for producing the case diary, who prays for some more time for producing the case diary, along with medical report also,
Injury report.
along with the injury report. The prayer is allowed. Let this letter be listed again on
21/12.
21 page. The interim order shall continue.
Item 54 is connected out, arisen out of the same FIR law. 54. In this case, Lordship, there are 3 petitioner Lordship. 2 petitioners are on interim Lordship and 1 is not on interim Lordship.
54 also. Heard Mr. J. Abbas, learned counsel for the petitioner, also heard Ms. S. H. Bora, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed again on
21/12.
21 page. The interim order shall continue.
Lordship, in the case of 1 petitioner, there is no interim. So I'm saying
You have to wait.
Lordship.
Wait till next.
46,
May I read your lordship?
46 also, Lordship, city is not available.
It was called for interim.
Petitioner is an interim. Lordship.
Heard Ms.
M. Soikia.
L. Soikia, learned counsel for also heard Ms. S. H. Bora, learned additional prosecutor, who prays for another day for producing the case diary. Prayer is allowed. Let this matter be listed again on
15/12.
15/12.
That's an interim may be continued.
Interim order shall continue till next day.
47,
May I please, Your Lordship? Lordship, CD was called for.
Lordship, your search sheet has been filed, Lordship.
I am on interim Lord.
Whether you appeared before the IO.
Yes,
after-
ma'am.
after. Heard Mr. H.
Yes, okay.
A.H.
Okay.
Soikia, learned counsel for the petition. Also heard Mr. Miss S.H. Bora, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been paid, bearing charge sheet number
By CS number 64 of 2023, dated 17/11/2023.
On the other hand, learned counsel for the petitioner has submitted that by order dated 19/10/2020, the petitioner was allowed to go on interim anticipatory bail, and in pursuant to the said order, the petitioner has appeared before the investigating officer and has cooperated in the investigation. In view of submissions made by learned counsel for the petitioner, as well as in view of laying of the charge sheet, the interim anticipatory bail granted to the above named petitioners. Name petitioners by order dated 19/10/2023 is hereby made absolute, with condition number 2, 3, and 4 attached to the said order remaining intact.
Highly obliged, Your Lord.
With above
Obliged.
observation, this bail application is hereby disposed.
Obliged, Your Lord.
49,
May I please, ma'am? My lord, before going to the fact of the case, my lord, in the present bail petition, there are 5 petitioners. However, my lord, during the pendency of this petition, my lord, petitioner number 2 was arrested, my lord. But, my lord, without withdrawing the present petition, my lord, by the petitioner number 2, my lord, petition number 2 prepare and bail petition, my lord, and this court, my lord, on 28, my lord, yesterday, my lord, allow this petitioner to go on bail, my lord, in respect of petitioner number 2.
Whether have you made submission at the time
No,
of
my lord, I have not been informed, my lord. Some other counsel was appeared, my lord. They filed the bail petition and took this honorable court allowed yesterday, item number 21, my lord. Honorable court allowed the bail petition.
That is
I only-
VA lordship, this is anticipatory. bail.
Yes,
no, the question of propriety yesterday,
Yes.
whether it was informed or not. Okay, then
my lord. And the present case, my lord, there is a dispute between this present petitioner and the informant, my lord. There is land dispute, my lord, regarding the ancestral property, my lord. And there is then, my lord, this false injury affair was.
case diary is there.
CD is available. Lordship.
What is the injury?
Lordship, 2 persons sustained injury, lordship, and 1 person sustained lordship previous injury with sharp object. And it is on chop wound has been found on the right maxillary region, that is on the facial part,
Caused by
sharp weapon.
who has caused?
Lordship, all the petitioners' name has been reflected from the statements of the witnesses.
My lord, affair was filed in the month of January 2021, my lord. The police might have, my lord, completed the investigation. Substantial detention may not be necessary, my lord. It's 2020, January 2021.
Case is registered under section 326
and 379.
I found no such ingredients of 379. Which of 326 is considered of sharp.
My lord, those are not grievous injury, my lord. In any condition,
Injury
my
was
lord,
caused
they
by
are maybe allowed.
sharp weapon, previous injury.
What are the materials against the
Lordship, they have very specifically, they have their name lordship by the state witnesses lordship. May I read one of the মোৰ নাম মোৰ ঠিকনা so হয় ইংৰাজী so তাৰিখে সন্ধিয়া অনুমান 24 বজাত মই অমুক বজাৰ কৰি থকা অৱস্থাত হঠাৎ বজাৰৰ কাষত ৰাস্তাৰ ওপৰত চাৰিওফালৰ পৰা উপৰোক্ত পদকীয়াখনে আগুচি ধৰি গুষ্টৰিয়াৰ ল'ৰা আব্দুল ৰেজাক আৰু আব্দুল কুবৰক মাৰপিট কৰি মুখেদি তেজ বাহিৰ কৰি দি জখম কৰে। পিছত মই আৰু বজাৰৰ মানুহবিলাকে হাই কাজিয়াত মাৰপিট কৰা ভাঙি দিয়াত আছামী গোলাপ হুছেইন, আমিনুল ইছলাম, আলী নুৰ ইছলাম, নুৰ হাকিম আৰু নুৰ সিদ্দিক সকলো এই ঠাইৰ পৰা গুচি যায়। Same sort of statement has been given by all the witnesses. They all are named.
What is your submission?
গালি গালাজ কৰি বাঁহৰ লাঠিৰে মাৰপিট কৰি জখম কৰে।
Where is the order of the bail?
My lord, this order may not be online, my lord. Order dated 21, yesterday order, my lord, item 21. Bail petition number BA 4120-2020.
You produced, show me that order tomorrow. We are fixing it tomorrow.
In morning, I asked my lord, well, it was not in online, my lord. It might have later appeared maybe online. 4120.
Heard Mr. A.M. Hassan, learned counsel for the petitioner, also heard Ms. S.H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by 4 numbers of petitioners, namely Gulab Hussain, Aminul Islam, Noor Siddiqui.
My lord, type it.
5 numbers of petitioners. Aminul Islam, Noor Siddiq, alias Noor Siddiq, Aminur Islam, and Noor Hakim, who are apprehending their arrest in connection with Mankasar PS case number 16/2020. When he was arrested,
But he was arrested on 2710.
after learned counsel for the petitioner had submitted that during the pendency of this anticipatory bail application, petitioner number 2, Aminul Islam, was arrested in connection with this case, and on 27/10/20, and thereafter he was allowed to go on bail by this court in bail application number 4120/2023 by order dated 28/11/2000. Okay. Who caused the injuries on his neck? Nose, it is not specifically mentioned.
And all are named, doctor.
All are named, all have assaulted,
Yes,
but who caused the injury?
yes.
Not in. But in any condition, my lord. Even my lord, to January 2021, my lord.
And statement of victim is there.
Lordship, just after some time.
It is not there. It was not there yet.
Lordship,
Yesterday it was not there.
Okay.
Or you go through it.
yes, just after some time.
I'll dictate order after.
Yes,
the
sir.
process. Call it after some.
No.
Okay.
Item 50.
Yeah, please. I am on interim, my lord. I have already appeared. My statement already has been reported.
50 Lordship, city is not available.
Heard Mr. S. H. Sikdar, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor, who prays for another date for producing the case that the prayer is allowed. Let this case be listed again on
14/12.
14th. The interim order shall continue till next.
51,
Lordship, scanned copy of LCR was called for. Perhaps there is a office note, Lordship, that I didn't see.
Office note regarding scan copy has been received.
Yes, yes. That
It is available.
Yes, what is your submission?
My lord, the petitioners, my lord, in the FIR, my lord, altogether, my lord, 36 accused were named, my lord.
36.
36, my lord. FIR case 10. Then, my lord, during investigation, my lord, 15 persons, my lord, arrested. And charge sheet was submitted, my lord. Partial charge sheet was submitted. And they approved this all court. This all court, my lord, granted bail, my lord, page 82, my lord. Page 82, my lord. And in the charge sheet, my lord, we have been shown as absconder.
Then
in the cross case, my lords, in cross case, my lord, that is also, my lord, to case, my lord. 12 persons were, my lord, named, 5 were arrested, and others were shown arrested in the charge.
in this case, how many were charge sheeted?
36, my lord.
Against how many people charge sheet was?
25.
25. Out of 25, how
50
many are?
granted bail.
How many are on bail?
15, my lord. 1.
15. And presently 9 are before.
Lost it. And in our case, my lord, similar case, 302, my lord, there also, my lord, charge sheet was submitted. Some
No,
were
whether summons were issued.
My lord,
to you.
summons has been issued, my lord. I have annexed the summons, my lord. Page 88, my lord.
What is the next date fixed?
Next date, my lord, 16/12, my lord. And you lordship's order, my lord, in similar case, my lord, in our cross case, page 89. So our submission, my lord, will appear, will, my lord, face the trial, will cooperate with the trial, my lord. And police, my lord, although, my lord, there is no direct implication against us, police has been shown as absconder.
No, against you, non-bailable warrants are not.
No, only someone has been issued. And
Then why are you apprehending?
apprehending, my lord, criminal court, my lord, 302 case has been registered. We have been shown arrest, my lord, shown absconder. Actually, tribal by session judgment.
Let him appear, Lordship, and the trial
And
court. will
similar
decide
order,
what
my lord,
is
page
what.
90, my lord, you lordship.
The committal court may not grant it
Lordship.
Yes.
because of the
Yes, 302 is involved.
how Mr. R. Ali, Senate Counsel for the petition. Also heard Ms. S.H. Bora, Senate petitioner. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by 9 numbers of petitioners, namely 1, 2, 3, 4, 5. who are apprehending that though the committal court has issued summons to them in connection with PRC case number 41420/23. However, as one of the offense involved in this case is under section 302 of the Indian Penal Code, they may not be allowed to go on bail on their appearance before the state court. The what is at page 84?
My lord, arrested persons were released on bail.
In the same case.
Got them. 15 persons were arrested, 12 were released on bail, and in another case, 33 were released. Total 15 were released on bail.
The gist of accusation in this case is that quote the gist from page number 84 of the data. I have marked it date. Learned counsel for the petitioner has submitted that after completion of the investigation, charge sheet has been laid against 25 numbers of accused persons, including the present petitioner, under section. Where is the charge sheet?
Charge sheet, my lord.
Under section 120B/147/341/326/302/435 of the Indian Penal Code. It is submitted by learned counsel for the petitioner that though the present petitioner, name of the present petitioner are shown as absconder in the charge sheet, and though the committal court has issued summons to them, to the present petitioner. However, as one of the offense involved in this case is under section 302, for which the maximum punishment prescribed is death penalty. And therefore, due to the embargo provided in section 437 within bracket 437(1) within bracket 1 within bracket Roman 1 of the Code of Criminal Procedure, a court of magistrate, the committal court, which is the court of, in which court the case is?
Chief Judicial Magistrate, madam.
Is the court of Chief Judicial Magistrate. Chief Judicial Magistrate Gorveta may not grant bail to the present petitioner, and thereafter, and if the present petitioners are not granted bail, then as the case is triable exclusively by Court of Session, they would be remanded to custody under section 209 within bracket A of the Code of Criminal Procedure. The petitioner, learned counsel for the petitioner, submits that in the meanwhile, 15 other co-accused persons have already been granted bail by not 15, 12. 12 other co-accused persons have already been granted bail by this court in bail application number 2161/2023 by order dated 24/7/2020. And the petitioners are willing to face the trial and are ready to cooperate in the trial. So I have considered the submissions made by the council for both the sides and have perused the materials available on record, including the scanned copy of the PRC case number 1420/20. Stop. Though it appears from record that though only summons are issued against the present petitioner by the committal court. However, as one of the offense involved in this case is punishable with death penalty, therefore, due to the embargo of section 437 Roman 1 of CRPC, the committal court may not grant bail to the present petitioner, even if they appear before the said court in pursuant to the summons received by the present petitioner. And as the present petitioners are willing to face trial, and as some of the co-accused persons are already allowed to go on bail, their custodial detention does not appear to be necessary if they cooperate in their trial. So, for the reasons mentioned herein above, the petitioners are directed to appear before the learned committal court in pursuant to the summons received by them on
The next date is 16/12.
on 16/12/2023, and if they do so, and if they appear before the learned committal court in pursuant to the summons issued by it, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the learned additional chief judicial magistrate Borpeta. At the time of with following condition. Number one, the petitioners shall cooperate in their trial and shall not, number two, they shall not make any directly or indirectly make any inducement, threat or promise to any of the witnesses, enlisted witnesses / any other person who may be acquainted with the facts of the case, so as to dissuade such person from deposing against the petitioner in the pending trial against them. Number three, the learned committal court / trial court may add any additional condition of bail if it thinks fit to do so, if it deems fit to do so. With above observation, this anticipated bail application is.
Lordship, one more observation may be added, Lordship. He shall not leave the jurisdiction without the prior permission.
He shall not leave the jurisdiction of the learned trial court. The petitioner shall not leave the jurisdiction of learned trial court without prior leave of the learned trial.
Earlier.
52.
Wait, this is your lordship. It was called for in.
Your Lordship, Percy has been late.
Have you appeared after?
I have appeared.
Heard Mr. B. Bora, learned counsel for the petitioner, also heard Mr. S.H. Bora, the additional public prosecutor, who has submitted that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
08/2023, dated 15/11/2023.
Learned counsel for the petitioner has submitted that by order dated 8/11/2023, the petitioner Shri Biju Saikia was allowed to go on interim anticipatory bail by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. In view of submissions made by learned counsel for the petitioner, as well as in view of laying of the charge sheet, the interim anticipatory bail granted to the above named petitioner by order dated 8/11/2023 is hereby made absolute, with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is thereby disposed.
53,
Let's check case of 376 of the petitioner is on interim docket, and he has already appeared for the IO.
CD,
CD received document. Allegation of 354A is there. Okay.
he has appeared.
He has appeared, statement recorded.
What is your submission?
Otherwise, Lordship, an attempt was there as per 164 statement of the victim. And he appeared before the IO.
Heard Mr. D. Bhuya, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 8/11/2023, the petitioner, namely Muhammad Amzad Ali, was allowed to go on interim anticipatory bail by this court. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Mollygot Rural PS case number 30/2023 and has submitted that though there are incriminating material against the present petitioner in the case diary, however, he has appeared before the investigating officer and his statement under section 161 CRPC has also been recorded. So considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 8/11/2023 by this court is hereby made absolute, with condition number B attached to the said order remaining intact. B within the bracket. With above observation, this anticipatory bail application is hereby disposed of. Send back it.
Deeply obliged.
55,
55 Lordship, CD was called for, but we have not received.
My Lord, please, Lordship. FIR is page number 12.
But CD would be required.
Allegation of 376 is there.
370. Heard Mr. T.K. Bora, and counsel for the petitioner. Also heard Ms. S.H. Bora, and an additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on
1512.
15/12.
56,
Applicable. The 438 application notice. FIR will find it page 7. Allegation is under section 341, 386, 506, 34 IPC.
$386. What is the section?
86, some money was credited to one joint budget portfolio account. Lordship, I have annexed the transaction receipt located page 10 onwards. Lordship. The money receipt. Lordship.
No, yes, make your submission.
What happened? Lordship, the story is that Lordship, while the informant Lordship is carrying some cattle, Lordship, as per the allegation in the FIR, Lordship, they have intercepted the vehicle, Lordship, and handed over to the police, Lordship.
Then Lordship, what happened is the incident took place in 11 PM Lordship, and they said money was credited in the last night Lordship to one joint deposit board Lordship. What happened Lordship, that due to Lordship that incident that they have intercepted the vehicle and handed over to the police Lordship, and he has credited the said amount to joint deposit board Lordship late night Lordship, and subsequently he has lost the instant FIR Lordship that they have taken to.
No, what money has been credited? Is 50,000.
No, look, as per the FIR, it is 30. They, as per the FIR, it was demanded 50,000 rupees, and he has paid 33,000.
Who demanded 50,000?
As per the FIR, look, the one Abhijit, joint deposit board, may I read the FIR, look.
You are Abhijit.
I'm Abhijit Kunikal, look. May I read the FIR, look.
At the time of occurrence, both this Jointo and Abhijit were present. They have compelled to give some money, and they had demanded some money amounting to rupees 50,000, and they have compelled to transfer from their account rupees 33,000, and that is reflected in the that amount has been deposited to Jointo. And at that relevant point of time, both the persons are together.
Look, it was credited in the last night, look. Late night, look. Incident took place in as per the FIR, 11 PM, look. And
11 PM is also late night.
Look, the amount credited, let's say, as per the, I have annexed the state.
No, what is your submission? Allegation against you is that you forcefully compelled the.
No, look, the money was not
to
credited.
transfer the money.
No, money was not credited to my account, look.
The two persons, Jointo and the present. The money was transferred to Jointo.
Joint deposit, look.
And
You are Abhijit.
I am Abhijit, look. The money was credited to joint deposit board, look. His account, look.
But you also threatened.
Yes.
Look.
So he
As
did.
my instruction was his vehicle was his, look.
Whose
He was not there. The Abhijit Municipal vehicle, look. He was not there in the incident, look. That's my instruction, look.
And found to be habitual offender, doctor. And in the earlier occasion, they have been arrested in some other cases, similar offenses.
Okay. No, prior, apart from the
Yes, sir.
allegation of prior offense,
Lordship.
what are the materials in this case?
Because also, all the victim statement, they have 3-person statement has been recorded along with the victim profit. The money has been transferred, threatened them, and put under threat, demanded money, and compelled them to transfer the money to them. That has been reflected in it.
Money has been credited to joint deposit board, look, account, look. Not my
He
account.
was there. Then they have been named by the victim.
Yes, his name because of his vehicular use.
I'm reading one of the statements of it. To ইংৰাজী so and so তাৰিখে মই চিমেণ্ট চাপৰি গৰু বজাৰৰ পৰা গৰুখিনি আনি থাকোঁতে ৰাতি প্ৰায় 11 মান বজাত জলকীয়া গুটিত মোৰ গাড়ীখন এখন আৰ্টিকা বাহনে আগবাঢ়ি ধৰি ৰখাই দিয়ে আৰু গাড়ীখনৰ পৰা শ্ৰী জয়ন্তী বৰদলৈ আৰু শ্ৰী অভিজিত খনিকৰ নামি আহি মোক ভয় ভাবুকি দেখুৱাই 50,000 টকা ডিমাণ্ড কৰে। মই দিব নোৱাৰো বুলি কওঁতে মোক আৰু মোৰ লগত থকা গাড়ী চালকৰ হেণ্ডিমেনক মাৰিবলৈ বিচাৰে। উপায়হীন হৈ শ্ৰী জয়ন্তজিত বৰদলৈ একাউণ্টত 33,000 টকা গুগল পে আৰু ফোন পে যোগেদি দিওঁ। মই আজি 24 তাৰিখে ন্যায় বিচাৰি the 3% subsequent, the handyman driver and the owner.
What is it?
Uh,
Whether
otherwise,
custodial detention would be.
let them refund the money.
Heard Mr. T. Sutia, learned counsel for the petitioner. Also heard Ms. S.H. Bora, an additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Abhijit Kanikar, who is apprehending his arrest in connection with Sila Patar PS case number 211/2023 under section 341/386/506/34 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 14/10/2023, one Amal Kumar Gokoi had lodged an FIR before the officer in charge of Hilapathar Police Station, inter alia, alleging that on 13/10/2023 at about 11 p.m. when the first informant was transporting some bulls from Simon Sapuri towards Silapathar, two persons, namely one Jointojit Bordoloi and the present petitioner intercepted the vehicle with their vehicle of the informant with their Ertiga vehicle and demanded 50,000 rupees from the informant after threatening the informant to kill him and being compelled, the first informant transferred rupees 33,000 through Google Pay and Phone Pay to the said culprit, to the Jointojit Bordoloi. Learned counsel for the petitioner has submitted that the petitioner was, you were present there.
No, if I'm instruction, he was not present. His vehicle was
He was present.
The petitioner was not present at the place of incident. However, his vehicle was used by Jointojit Bordoloi. It is also submitted by learned counsel for the petitioner that the money has also not been transferred to the account of the present petitioner, but to the account of the Jointojit Bordoloi. What else is your sub?
My submission is that the incident took place on 11 losses, and the vehicle intercepted handed by police losses. Last night losses that he has credited the said amount losses to losses hampered his present petitioner's losses. I have already stated my paragraph losses in my petition losses. Paragraph 4 losses, page 4 losses.
Okay.
The page 3 paragraph 3 losses.
Learned counsel for the petitioner has also submitted that from the transaction detail of the account of Jointojit Bordoloi, it appears that the money was transferred to the account of the said Jointojit Bordoloi only at 1:01 a.m. and thereafter, which according to present petitioner, the informant has deliberately paid lately only to implicate the said Jointojit Bordoloi. However, it is said Jointojit Bordoloi. However, it is also submitted by learned counsel for the petitioner that even if money has been transferred, same has not been transferred to the account of the present petition. On the other hand, learned additional public prosecutor has submitted that there are implicating materials against the present petitioner in his case diary, and it appears that he was also present at the place of occurrence when the when the informant was treated, it is also submitted that though the money was transferred to the account of another co-accused, namely Jayantajit Bordole, there are allegations of the present petitioner threatening the informant or making such transfer of money. Otherwise, witnesses
Yes.
recorded.
Witnesses statement has been recorded.
Learned counsel for the petitioner has also submitted that in the meanwhile, the investigating officer has recorded the statement of relevant witness. I have considered the submissions made by learned counsel for the petition, as well as learned additional public prosecutor, and have perused the case diary of Silapat RPS case number 211/2023, which was called for in connection with this case. It appears from record that though the witnesses whose statement have been recorded by the investigating officer under section 161 of the CRPC have implicated the present petitioner also. However, it also appears that the informant has transferred the money to the co-accused Jayantajit Bordole and not to the present petitioner. And considering the fact that the relevant witnesses have been examined by the petition investigating officer and the petitioner is ready to cooperate in the trial, his custodial detention may not be necessary if he otherwise cooperates in the investigation. So, in view of above, the petitioner, namely Abhijit Konikor, is thereby directed to appear before the investigating officer of Silapat RPS case number 211/223 within a period of 10 days from the date of this order and cooperate in the investigation. And if he does so within the stipulated period of time, in the event of his arrest in connection with Silapat RPS case number 211/2023, the above named petitioner shall be allowed to go on bail of 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number one, above observation, the anticipatory bail application is thereby disposed and back the case.
Starting 49.
Lordship, I
It's
have
not there.
found the victim statement. is
Not
not there. Yes. Otherwise, I'm objecting because P26 is attracted.
What was the and he is ready to operate with the industry. How long you are? No, this is anticipated. On the other hand, learned additional public prosecutor has produced the case diary of Mankasar PS case number 16/2021 and has opposed the grant of bail to the present petitioner on the ground that the victim in the case has sustained grievous injuries caused by sharp weapon, and therefore it is not a fit case where bail may be granted. He also submits that the witnesses who have been examined by the investigating officer during investigation have implicated the the accused persons named in the FIR, including the present petition. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record, including the case diary of Mankasa PS case number 16/2020. On perusal of the case diary, it appears that though there are implicating materials against the present petitioner, and though the victim has sustained grievous injury caused by sharp weapon. However, the statement of witnesses recorded under section 161 CRPC are general in nature and does not specifically mention as to as to whether the present petitioner had caused the said injury on the victim or not. It also appears that the investigating officer has not. It also appears that the statement of the victim is also not available in the case diary. On the other hand, one of the co-accused has already been granted bail by this court. One of the co-accused, namely Aminul Islam, has already been granted bail by this court. Further, it also appears that the incident alleged in the FIR had occurred 2 years ago, that is in the year 2020.
January 20.
In the year 2021, in the month of January. And therefore, custodial detention of the present petitioner under the above facts and circumstances does not appear to be necessary if he otherwise cooperate in the investigation. Stop. Considering the above facts, the petitioner, namely
Four
the petitioners, plural, subplural,
Except the petitioner number 2.
Two. One Gulab.
petitioners, namely Gulab Hussain, Noor Saddiq, Ali Noor Islam and Noor Hakim are hereby directed to appear before the officer in charge, the investigating officer of Mankasar PS case number 16/2021 and cooperate in the investigation. 2021 within 10 days of the date of the person and cooperate. If they do so within the stipulated period of time, they shall be allowed to go on bail of rupees 30,000 with one security of like amount to the satisfaction of the arresting authority subject to following conditions. The above named petitioners shall appear before the investigating officer of Mankasa PS case number 16/2021 every week for next 4 weeks or till the investigation is completed, whichever is earlier, and shall cooperate in the investigation. Number 2, that petitioner shall not directly or indirectly make it with above the
57.
57, Lordship. CD along with the medical report was called for that we have not received.
Well, the petitioners are the family member, all are same family member. We are not in favor.
When can you?
Lordship, it's from,
Patakal.
let it be on
Patakal.
11, 12.
Not Mr. And the Learned Counsel
Oh,
for the
what
petitioner
is it?
also heard Ms. S.H. Bora, the petitioner public prosecutor, who prays for another date for producing the case. Where is the number? Let this case be listed on 11th of
11th.
December for case diary as well as injury.
73 of the supplement.
None appears for the petitioner on call. Let this matter be listed on fourth of
Lodge.
Matters for admission, site 53.
The contents of the affair. The affair is challenged on the probative end of the FIR, my lord. The FIR is page 33. Here, my lord, this petitioner is not should not be implicated, but how he is implicated, my lord?
whether case diary is there,
No, your lordship, today the case the daddy has not yet come.
case diary would be required.
Yes, my lord, 1 year he is waiting without any bail, my. So,
No bail, this is not bail.
yes, my lord, so that is a problem, my lord. In case of bail, my lord, they can brought it within 1 week, 4 weeks, but it's more than 1 year.
When can you?
Your lordship, I'm on behalf of respondent number 2.
Two, oh, sorry.
Yes.
Yes, Ms. Bora. Case diary would be required,
Yes.
or will it not be required?
Lodgeship CD may be required.
It is for, what is your prayer?
My lord, quashing of the affair.
FIR, case diary would be.
Yeah.
My lord, if it's the last chance, maybe you can, my lord, otherwise they can never, my lord. In case when bail petition is moved, they promptly brought it. Now, for a petition, 1 year is waiting. So if anything is there, I can put.
Your lordship, I have taken it there in the ground, like regarding all anticipatory bail applications that the petitioner had raised. In there, the CDs had come and the honorable court has taken the observations there that the prime facie case has been found against the accused, the petitioner. So,
Still, we have
CD will be
heard Mr. M.J. Bora. Also heard Ms. S.H. Bora, the petitioner, as well as Ms.
M. Chatterjee,
M. Chatterjee, Learned Counsel for respondent number 2. Learned Additional Public Prosecutor submits that though the case diary was fought for, however, same has not arrived, and prays for another date for producing case diary. On the other hand, only case diary or LCR also?
CD along with the status report.
No, what is the stage? FIR has been lodged.
Yeah.
Thereafter, charge sheet has been laid.
No, my lord, nothing.
we don't, not aware of the status of the bail.
Therefore, status report will be required.
Your lordship, the
No,
informant
if case
actually,
diary comes, we will be knowing.
Yes.
yes, your
Lordship.
lordship.
Short death may be fixed, my lord, with last terms, my lord. Otherwise, I may.
Learned Additional Public Prosecutor is requested sure production of Ojai PS case, production of case diary of Ojai PS case number 691/2021 on the next date fixed. That is
18th.
18. Let this case be listed.
It should be last, my lord. Otherwise, this pair.
Not mentioning anything.
Yes.
24.
My lord, here is the 482. I'm challenging the charge sheet, my lord, on the basis, my lord, because the prosecution has a respondent number 2, the service is complete. My lord, after service also they have not appeared. There is a judicial order, the service is complete. As regards, my lord, the quashing of the charge sheet, my lord, my ground was there in the
Quashing
same.
of charge sheet.
Charge. My lord, because my whole case is, my lord, there the prosecution has withheld some of the documents which were there before the same police station. Because my case, their case against me is subsequent to my case, for which I will not get a fair trial. That is why, my lord, I wanted a reinvestigation. That is why, my lord, the proceeding has been stayed already by this court.
Now, whether it can be heard finally.
Now, my lord, it can be heard.
So the appearance of the matter respondent informant, it is necessary, Lord.
My lord, it's complete, my lord. Service is
No, Lordship may kindly peruse the, my lord, the ID card, Lordship. Who has received the, my lord, notice, Lord?
Because my lord, my friend cannot go above the judicial order. The
Yes,
judicial order says the service is complete.
Lordship, kindly see the, my lord, address of the respondent, Lordship.
Same address.
If it is sent to Madam, my lord, the address of the accused person, then how can he receive that, my lord? Whether she is residing in the same house till today.
Oh, okay. The respondent is Poonam Sharma. Who are you? Kalyan Sharma.
Husband.
To which address it was sent?
It was sent in that address given, my lord.
Kalyan Sharma sir.
My lord, they are staying in the same house in a different.
If she is residing in the same house, then nothing to add, nothing to submit.
That is why they are not coming, my lord. The issue is, my lord, now because they want a divorce also and they are getting maintenance. Outside the court, they are cordial now, my lord, for some other reason. For ego class, they are before the court.
Then let her appear.
Because, my lord, twice we have taken place by registered court. After receive also, there is a judicial order. I think, my lord, Justice A.D. Choudhury has passed that order.
Whether PD card is there? Where is the No, this is the ID. This is the ID card. In AD card, the addressee is Kalyan Sharma. Kalyan Sharma has signed.
That is what I was.
You have signed. You have yourself signed.
Then, my lord, again we have to take care.
The service is not proper. So there may
Not
be
proper and not complete.
because this step has been taken by you and it has been received by you.
Then, my lord, we have to. Then, my lord, I find from the petition, my lord, there is another one address for which I can send, my lord. Your lordship may look into this page. There is another one address petition filed by her, my lord.
Thereafter.
My lord, in page 51. page 51, my lord, there is another address.
Now, how to ensure? Mr. Bhut?
My lord, therefore, my lord, my lord, in this address of 51 Lord,
51 page, this address we can send it, my lord.
because this is the application filed by the petitioner Lord. This is
The respondent, the respondent.
The respondent petitioner. Yes.
This address we can send.
In this address, he is the informant. What she has alleged?
498 days.
That I have seen Lordship in the in her 164 statement Lordship, she has not made any such allegation Lordship regarding 498 and demand of dowry and all this. There is a quarrel between my lord that can be settled if provided she appears Lordship.
Nothing as such of allegation. That is why I am against the charge. The alternative, she is taking money every month from me. I am paying everything. Even I am paying more than 2 lakh rupees. I am paying back. I am paying all the royal school expenditures of my son and everything.
Heard Mr. P.K. Rocha, and counsel for also heard Mr. Rajiv. None appears for an additional purpose submits that considering the fact that the FIR has FIR against them, which is sought what has been filed by the respondent and also considering the fact that the acknowledgement due card received by the registry of this court, which was sent along with the registered post by which the notices were sent to does not show the signature of the respondent number 2 of the state card. It is hence learned additional prosecutor submits that considering the nature of the case, the presence of respondent number 2 would be necessary for proper adjudication of this case. And also considering the fact that the notices issued to the present petitioner to the respondent number 2 were not personally, does not appear to be have personally received by the respondent number 2. And additional prosecutor for issuing fresh notice to the respondent. On the other hand, learned counsel for the petitioner submits that at annexure 51, annexure H at page 51 of the criminal petition filed by the present an alternative address of respondent number 2 is also there, that is care of S.N. Mahanto, resident of Sonapur near SBI under PS Sonapur in Kamrup Metro District. Let and he also praised for allowing the petitioner to take steps on respondent number 2 on the stated there is a the petitioner shall take steps for issuance of fresh notice on respondent number 2 in the alternative address as provided. Page number 51. Within 3 days of the date of returnable after.
Let be the month of January.
Then this matter be decided on after 4.
Interim order to come.
The interim order shall
Sonapur village Dalupari, madam, it was mentioned. That is page 46 total.
Dalupari, PS Sonapur.
yes, no, in page 51, even
51 is also there and 46 also, madam. 46 is more specific. 51 resident of Sonapur.
Okay.
Sonapur village.
Sonapur
village.
Dalupari.
But Sonapur and Dalupari.
There may be a village in the village name in the Sonapur. Dalupari. There may be also, I don't know.
No, let it be as per the address given in 50.
Madam.
25.
May I please, Your Lordship, my lord, appeal against the acquittal, my lord.
Appeal against
originally-
acquittal.
My lord. Leave, already granted, my lord. And respondent number 2 here, respondent number 2 have appeared, my lord, but his name is not shown in the cause list. But other respondents are yet to be appeared. So Your Lordship may issue notice by admitting my appeal, my lord.
You have obtained the leave. Leave for leave petition has been allowed.
Allowed. That is on 29 2023, my lord, in IA number 18 of 2024.
Heard, Mr.
I allow.
I allow. So heard. Please repeat under section 14A of scheduled caste and scheduled tribe within bracket prevention of atrocity bracket Act 1989. Read with section 378 bracket 3 of the Code of has been filed impugning the judgment and order dated 2 passed by the additional section within bracket Kasta special case within bracket SCNS number 7/7 whereby respondent were acquitted of charges whereby issue notice as an additional purpose has appeared for respondent number 1 no formal
Respondent number 2 also appeared, my lord. The leave application, but today his name is not shown, my lord.
but in this case you have to take fresh
My lord.
as regards respondent number 2, 3, 4 and 5 the appellant shall take steps for issuance of notice on the said respondents by registered post within 3 days from date of its order, returnable after 4. Let this case listed after 4.
Here, LCR may be also.
Let the LCR, let the case record of special case number 7/2011 be called for from the Court of Law, additional secretary, FTC Kasar. The registry shall take step for requisition said case report. Let this matter be listed after 4.
26,
May I please know? Not appeal against the conviction of 7 years. And respondent number 2 already appeared. LCR may call for.
Heard Mr. S.A. Ahmed, that counsel for appellate. Also heard Mr. R.K. Purpose. This appeal, the section 374 within bracket 2 of the Code of Criminal has been preferred by the appellant Raj Sahini, impugning the judgment and order dated 2010 passed by the special judge within bracket POXO Guardian of Commodity in POXO case number 2/2017, whereby the present appellant has been convicted under section 4 of the POXO Act, 2012, and has been sentenced under simple imprisonment for 7 years and to pay a fine of 10,000 and in default of payment of fine further simple imprisonment for 2. Issue notice to the on as done an additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps in as per the mode prescribed by this court.
Already
Do you have it here?
Your Lordship.
Okay, not another paragraph. As Mr.
Yeah.
E. Ahmed has appeared for respondent number 2. No formal notice need to be sent to respondent. Let the case record of special POXO case number 2 of the 2017 be called for from Court of Law and Special Judge POXO Part. Let this case be listed.
My lord, I is here for paying. Let the LCR come. 13 months in captivity. I may be considered on receipt of the LCR.
Out Mr.
Yes, dear.
Out Mr. S.A. Ahmed. That something for also Mr. R.K. Purpose and additional public prosecutor, as well as the Mr. E. Ahmed, that counsel for this application under section 389 of Code of Criminal Procedure 1933 has been filed by the suspension of sentence which has been imposed on the present applicant by judgment and order dated 2010-2015 passed by the Special Judge Box of Karbi Anglong, Deepu in POXO case number 2/2007, which has been impugned by the present applicant in the connected appeal, which is registered as criminal appeal number 429/20. In the connected appeal, the case record of special POXO case number 2/17 has already been called for. The present interlocutory application shall be considered only after receipt of the case record. Let this matter be only after receipt of the HCR. So let this matter be stated along with criminal appeal number 429/23 after 4 weeks after receipt of NCR.
70 of the supplementary.
Case diary?
Yes. Well, case diary was called for, so we have received the case diary.
Ready?
Yes, Madam. Lordship, senior counsel is not present, maybe fixed day after
Not there.
Monday.
Friday.
Monday.
13.
Monday.
Okay, Monday. Heard Mr. G. Kaushik, Learned Counsel for Petitioner. Also heard Mr. Rajya Baba, Learned Additional Prosecutor, who has submitted that the case diary which was called for has arrived. However, Mr. Kaushik, Learned Counsel for Petitioner, prays for an adjournment on the ground that his senior, who is the conducting counsel in this case, has some personal difficulty. Considering the submissions made by the net counsel, if there is allowed, let this case be listed again on 4th of December. The case diary be retained till next
month.
For orders, item 58.
My lord, it's a conviction, my lord, under the Wildlife Protection Act, my lord. On the last occasion, my lord, the Learned Counsel for the Forest, my lord, he had to apprise this court as to the serial number of the Schedule 1 to which these animals belong. Kindly come to page 45, my lord.
No, but NCR has not kept the record.
My lord, it is there, my lord, but my lord, my pleaded case is that these are not scheduled animals. That is not included in the schedule, my lord. This judgment, my lord, in a most illegal manner, my lord, the peasant appellant have been convicted.
But otherwise also to consider your submission.
My lord, from the judgment also, my lord, it can be considered. Kindly come to page 45 for a moment, my lord.
Who is for the forest?
My lord, that's why short date was fixed, my lord, today. Page 40
Standing counsel forest.
page 45, my lord. 4 animals, my lord, are listed, my lord. Page 45. This is the offense report.
No, at least the council of forest.
I'll try to contact my lord.
Oh, name is not.
My lord, last time they appeared. my lord.
T-shirt.
In the judgment also, my lord, most surprisingly, my lord, the serial number is not mentioned. Just the judgment has been passed on assumption. I have shown page 45, these are schedule animal. Now the reasoning, my lord, will find page 38 of the judgment, para 38 of the judgment, page 67. Page 67, my lord. May I read, my lord, one? Page 67, my lord. Para 38. It is reiterated that the forest department witnesses have supported one another and thus fortified the prosecution version that animals seized were actually primates and gibbon, and on this material point there is no variation or discrepancy. There is also no cross-examination on this aspect. That in that view of the matter, even dehors the examination of a zoologist, I believe these forest officials that the animals seized were the ones included in Schedule 1 to the specialist. But judgment cannot be passed on belief, my lord. Specific, it has to be specific, my lord, serial number 13, 14, 15, whatever, of the Schedule 1. And my lord, regarding my cross-examination part, I did not.
No, which animals were found?
My lord, page 45, my lord. Page 45. This is the offense report I am referring to, my lord. Page 45 is the part of offense report.
Yeah.
My lord, kindly see this four primates, my lord, are listed, my lord, 1, 2, 3, 4. And along with this, one gibbon is there. From top second line, lordship will find one gibbon and 4 numbers of primate species under the family so and so. These are not part of Schedule 1.
Is vested black macaque.
My lord, these also not Schedule 1 animal. None of these are Schedule 1. Last time they could not submit, my lord.
For what offense you have been?
51-1, my lord.
What is the offense? Within bracket 1.
My lord, there is penalties, my lord. Any person who contravenes any provision of this act except chapter 5 so and so, or any rule or order made thereunder, or who commits a breach of any. My lord, contravention, my lord, is carrying, my lord, the forest animals, my lord. That is.
No, 51. One has to be read with some provision.
49, my lord, 49M.
What is 49M?
Possession, transfer, and breeding of living scheduled animal species. Every person possessing a living species of a animal specified listed in Schedule 4 shall report it. My lord, this is regard to Schedule 4. I am reading the new act, my lord. This is under the old act, my lord.
Yes, Mr. Khan, F. Khan. We have to hear the wildlife.
That is there. My lord, kindly fix it on Friday, my lord. And my lord may kindly mention in the order that they have to specify, they have to submit before the court as to which serial number of Schedule 1 these animals belong. My lord.
No, that is your submission. That will answer to your submission after hearing you.
My lord, can it be fixed on Friday, considering that they are not present today? And their name may kindly be shown in the cause list, my lord. Otherwise, my lord, we have a very good case, my lord. And my lord, the present appellant is behind the bar for almost 600 days, my lord. 596 days, my lord, as on today. 596 days, my lord. And we have a very good case, my lord.
But 49M says not about Schedule 1. It speaks about.
My lord, that I will clarify, my lord, next date, my lord. Kindly, my lord, it may be fixed on Friday. That is my prayer, my lord, showing the name of the.
Provided your slot is available.
My lord, that is. If madam can help.
Oh, Friday to 30th. This is Friday, no? Let us see whether
Friday, yes. My lord, that is also not mentioned in the judgment, my lord, that which provision has been violated. That is also not there. So Friday, my lord.
heard Mr. F. Khan, Learned Counsel for the appellant. None appears for. And record would be required. LCR.
So we'll try on Friday. If they cannot point out, my lord, then I'll get bail. We'll have a detailed hearing, my lord, on that Friday. I'll also place everything, my lord. The old act I have to place, my lord, because offense has been committed during that relevant point of time.
None appears for the respondent. You have served the notices.
Yes, yes, my they appear also, my lord, last occasion.
It appears from that the item number. The name of the Learned Counsel for the respondent has not been shown in the cause list. Though from record it appears that Mr. B. Sharma, Learned Special Purpose Provider, had represented the respondent on the last occasion. The history is therefore directed for the name of the Special Purpose Provider in the cause list as counsel for respondent, henceforth. It also appears that the HCR has not yet. I see. From which court?
My lord, from Karbi Anglong, my lord.
Issue reminder for
Special Judge Wildlife, Karbi Anglong Depot.
issue reminder for let this matter be listed again. Right. On 112.
My lord.
On
On 112.
On 112, along with the interlocutory application.
I'm grateful, my lord.
Yes. 59, we received wrong record. Record is not before us.
It may be fixed in the next paper.
No, for that also record, we don't have the record.
Record law. Yes.
I'm decision number 1, 2, and 3.
59.
Yes.
59, we cannot take up now because records are not there. So it is wrongly listed. You have to again wait for the cause list, new fresh cause list where this case is to be listed again. No orders.
60.
But if there is the interim order, till the listing.
No, that will continue in pursuant to the earlier order.
Oh,
Because today it is not listed.
That is lordship. Lordship. I for delay, lordship delay 159 days, lordship. In criminal appeal, lordship.
$159 days.
Yes, lordship.
What is the reason?
Lordship, I have stated in page 3, lordship. Lordship, the communication gap between applicant and his family member.
Yes. Stop out. Mr. Chaudhary, you are also.
I am for the respondent number two, Lordship. I leave it to Lordship regarding the Lordship condemnation.
Regarding the, if there can be my delay, but for what reason the delay has been caused, then we do not have any objection.
Out, Miss
P. Udhigari.
P.
Udhigari.
Adhikari, Learned Counsel for the petition. Also heard Mr. B. Chaudhary, Learned Counsel for the
Respondent number two.
respondent number two, as well as Mr. R.J. Burwa, Learned Petitioner for the project. This interlocutory application has been filed on the basis of an application under section 5 of the Limitation Act filed by the present applicant for condoning the delay of 159 days in filing the connected criminal appeal, wherein the judgment dated 4/11/2022 passed by learned additional session judge number 2, Kamrup Metro Guwahati, in sessions case number 131/2023 has been impugned. Learned counsel for the petitioner has been, learned counsel for the applicant has submitted that the present applicant is a permanent resident of Jaflong, Noyabosti in Sylhet district of Bangladesh. And after his conviction in the, after his conviction by the judgment dated 4/11/2022, which the petitioner has impugned, by which the petitioner is sought to, which the petitioner has impugned by filing the connected appeal. The mother of the applicant contacted one counsel from Guwahati. However, there was a communication gap between the applicant and his family member, and the earlier engaged counsel, due to which there has been a delay in lodging the, in preparing the connected criminal appeal. Stop. That is counsel for the applicant has explained the delay fully in paragraph number 3, 4, 2 and 3 of his application under section 5 of the Limitation Act 1960. Learned counsel for the respondent and learned additional public respondent number 2 as well as learned additional public prosecutor, considering the grounds taken by the applicant, have not opposed the prayer for condemning the delay in filing the connected appeal. Stop. Considering the grounds mentioned by the applicant in her delay condonation application in paragraph number 2 and 3, this court is of considered opinion that the delay in preparing the connected appeal have been sufficiently explained by the present applicant, and hence the said delay of 159 days in preparing the connected appeal is hereby condoned and this interlocutory application allowed. Let the connected appeal be registered and be listed according thereafter by the registrar. This interlocutory appeal.
Lakshmi, directing them to serve the copy, Lakshmi, appeal copy.
It has to be first registered.
Yes.
Will it be required in the order? Here it is not.
Yes.
Connected appeal be registered and be listed after 2 weeks.
Publish.
Sipar,
My lord, this interlocutory application is filed for suspension of sentence before granting bail to the petitioner of the applicant. So the applicant
LCR has arrived.
LCR received. My lord, they are supposed to file an objection, but no objection has been filed till date. The
Will you
other
be
hand-
filing objection?
My lord,
Not much, because we are also not right. Keeping the memo of appeal right now.
we have started there without the appeal of the
It has been listed.
several times, Lordship, this matter was listed. And today, Lordship, basically, I am insisting that the applicant, Lordship, he has been suffering, Lordship, from serious.
But this is an FPPS case,
Yes.
commercial quantity. So they, how much punishment?
10 years.
10 years.
And I have filed an additional affidavit in connection with an IA. Whereby, Lordship, one medical document is finished.
Regarding lots of suspension of sentence, there is a bar under the act.
Sir.
So that is to satisfy.
And that is there, that I will satisfy. But so far, this health condition is concerned, Lordship. It's a conditional bail, Lordship, that can be granted.
What has happened?
Well, case 67 in my IA, Lordship, that is additional affidavit on medical document, Lordship. Further, you will require.
But then hospital, the jail will help you in your.
Yes, Lordship, I have annexed one medical document in my IA also. That is here, Lordship, will find page 55. That is the jail doctor, Lordship, he has given the certificate. He has been suffering, Lordship, since long. Now his condition is very.
Let the report be,
Yes,
report be
Lordship,
called for. Lordship.
my humble submission, Lordship,
Report be
the
called
health-
for the jail authority.
report on
Lordship.
his health, Lordship, may be called
To the jail authority.
the jail.
I heard Mr. M. Khan, the counsel for the applicant. Also heard Mr. R.J. Burke, petitioner for the applicant, who prays for some more time for to file written objection against the bail for suspension of sentence as well as grant of bail of the present applicant slash applicant. On the other hand, Bennett counsel for the applicant slash applicant has submitted that the applicant is suffering from serious ailment and needs immediate medical attention. And that is an additional ground for seeking bail and suspension of sentence during the pendency of the connected. However, considering the submissions made by the additional the prayer for filing objection is allowed. If let the report be called for from the district judge where he is detained.
Morigao.
District Judge Morigao as regards the health condition of the applicant Abdul Samad. The registry to procure the report from State Superintendent Morigao before the next date. Let this matter be decided.
For that meeting.
So we require at least
Second-
15 days time. Lordship, to file.
Second of December.
18th April.
Of life.
18th December.
62.
You have to carry the bar.
Lordship, we have taken fresh steps, sir. But by office note dated 23/11/23, Lordship, the service report is awaited. But fresh steps have been.
Okay, we'll wait for third Ms. B. Burwa, learned counsel for the petition, who submits that the petitioner has taken fresh steps for issuance of notice on the respondent pursuant to the direction of this court by order dated 7/11/20. However, from the office note dated 23/11/23, it appears that service report in respect of the notices issued on the sole respondent still awaited. So let this case be listed again on await service report. Let this case be listed after 2 on 2012.
Lordship, the interim period.
The interim is
Lordship, no, Lordship, the interim period to be
after
considered.
service.
Lordship.
Interim order the prayer for interim relief will be considered only after service of notice of sole.
DP, okay. 74 of the.
May I please your lord? Lordship, as per office note dated 12/10/2023, my lord, service report from the district magistrate is awaited, my lord.
Mr.
A guy.
A.
Gayan.
Gayan, learned counsel for the petitioner, also heard Mr. Rajya Bagoda, petitioner. As per service report dated 12/10/23, appears that the service report on which respondent?
Respondent number 2, but my lord, however, service report from the district magistrate is awaited, my.
Service report from the district magistrate of Dalguri and district magistrate of Maharashtra as regards services of notice on respondent number 2 still available. So wait for the let this matter be out. Or
Much obliged, ma'am.
My lord, sorry for the inconvenience, but there was an item 67 for delivery of order, my lord. We were under the impression that it will be delivered at 2, my lord. So we,
the sentence is suspended.
suspended, my lord.
Petitioner is allowed to vote fresh bail.
Ma'am.
You both
My lord, DP of that.